Good morning, everyone. I am Vanessa Acaron Toro, Director of the Planning and Engineering Office of the Energy Bureau of the Puerto Rico Public Service Regulatory Board. It is 8:35 of the morning of Tuesday, May 18, 2021, and we are commencing the technical conference in case number NEPR-MI-2021-0007, review of Luma's terms of service. We are holding this technical conference remotely as a precaution to avoid the spreading of COVID-19. We would like to welcome the Luma representatives and Prepa representatives and those who are watching us via our YouTube channel. This morning, we are joined by Edison Avila Estelis, Chairman of the Energy Bureau.
Good morning and welcome.
And Associate Commissioners Ángel Rivera de la Cruz,
Good morning.
Lilian Mateo Santos,
Good morning.
Ferdinand Ramos Segard,
Good morning.
and Silvia Ugarte Araujo.
Good morning.
Also joining us today is Energy Bureau's consultant, Guy Massa.
Good morning.
On February 24, 2021, Luma Energy LLC as Management Co. and Luma Energy Servco LLC as Servco filed before the Energy Bureau its petition for approval of initial budgets and related terms of service. As part of its petition, Luma requested the review and approval of the initial budgets and the terms of service. As part of the analysis, the Energy Bureau determined to be more appropriate to evaluate the terms of service request in a separate proceeding. On May 4, 2021, the Energy Bureau opened the instant case to evaluate Luma's terms of service. Further, the Energy Bureau issued the procedural calendar in this case, where it established it would hold today's technical conference. The Energy Bureau also required Luma to file additional information regarding the terms of service petition. The Energy Bureau required Luma to, during the technical hearing, present and discuss thoroughly its terms of service petition. Further, the Energy Bureau required Luma and its consultants to be prepared to answer questions from the Energy Bureau, its staff, and consultants regarding its presentation and all aspects of the aforementioned petition. This technical conference will be conducted in English and will be recorded in audio and video. Further, it is being streamed live both in English and Spanish through the Energy Bureau's YouTube channel. A copy of the recording of the technical conference will be made part of the administrative file of this case and will be available in the Energy Bureau's website. We will now establish the instructions to be followed during this technical conference. Afterwards, Attorney Torres Miranda will take the oath to the witnesses that will appear today before the Energy Bureau on behalf of Luma and Prepa. Before answering any question or addressing the Energy Bureau, all participants must identify themselves for the record by stating their full name, position in Luma or Prepa, or whether they are a Luma or Prepa consultant. Before addressing the Energy Bureau, please unmute your microphone. Please keep your microphone on mute while not answering questions or addressing the Energy Bureau in order to avoid disturbances due to background noise. As established in the agenda, we will begin with a presentation by Luma. Attorney Torres Miranda, please continue with taking the oath to Luma's and Prepa's representatives that join us today.
Thank you, Engineer Acaron. I am Antonio Torres Miranda. I will be administering today's oath. Based on the information of Luma's legal representative, the following Luma employees or consultants appearing on behalf of Luma have joined today's technical conference and may answer questions for the Energy Bureau. Once you hear your name, please say present. Mario Hurtado, Vice President, Regulatory.
Present.
Mr. Branko Terzic, Independent Expert.
Present.
Mr. John Stone, Director of Risk Management, Luma.
Present.
Mr. Kaylin Koski, Manager Accounting, Luma.
Present.
Attorney Mercado, please confirm that the foregoing are all of the Luma representatives that have joined us today and will provide testimony.
Good morning, Margarita Mercado, counsel for Luma. Indeed, I can confirm, Attorney Torres, that those are the Luma representatives who will be providing testimony this morning.
Okay, thank you. Now this is addressing to Prepa. Based on the information provided to Prepa's legal representative, the following Prepa employees have joined today's technical conference and may answer questions from the Energy Bureau. Mr. Leonel Santa.
Present.
Mr. Sammy Rodriguez.
Present.
Mrs. Noriet Figueroa.
Present.
Attorney Bolaños, please confirm that the foregoing are all of the Prepa representatives that have joined us today and will provide testimony.
Good morning, Attorney Torres. Yes, they are.
Okay, thank you. To all the witnesses, once I have read the oath, I will again mention each name independently for you to give an audible affirmative answer for the record. Do you affirm that the testimony that you will provide today is true, correct, and based on your own and personal knowledge, and that to the best of your understanding, none of the information you will provide today is misleading or untruthful? Mr. Mario Hurtado.
Yes.
Mr. Branko Terzic.
Yes.
Mr. John Stone.
Yes.
Mr. Kalen Koski.
Yes.
Mr. Leonel Santa.
Yes.
Mr. Sammy Rodriguez.
Yes.
Mrs. Noriet Figueroa.
Yes.
Let the record reflect that all witnesses answered in the affirmative. You may continue, Engineer Acaron.
Thank you, Attorney Torres. Now, before proceeding, Attorney Mercado, do you have any opening comments or remarks?
Thank you, Ms. Acaron. Good morning, Attorney Margarita Mercado, counsel for Luma. We thank the Bureau for the opportunity to appear this morning and discuss and answer questions on the petition for approval of terms of service. We propose to initiate our discussions and the portion of presentation with a summary testimony and statement by Mr. Mario Hurtado, Vice President Regulatory, followed by a summation of his testimony and opinion of Mr. Branko Terzic. Both of these testimonies were pre-filed before this Bureau on May 14th. So if the record reflects their pre-filed testimonies, they will be offering an initial summary to spearhead the discussions with the Bureau's authorization.
Good morning, and before Mr. Hurtado's discussion or Luma's presentation, and without taking a stance or position in the issue, I would like in Luma's presentation an answer to this question. Why the Bureau should grant gross negligence or willful misconduct liability waiver when it is not typically granted in other jurisdictions. I would like to see that in the discussion, and that Mr. Hurtado and the other Luma staff members address this question. Thank you.
Thank you.
Mr. Chairman. I'll start just briefly in Spanish. Buenos días, señor presidente del negociado de energía, comisionados y personal del negociado y consultores. También le doy la bienvenida a los miembros del público que nos acompañan por el canal YouTube del negociado de energía. Quería comenzar solo dándole notificación al público que Luma preparó una presentación en español sobre los documentos presentados al negociado para comenzar la operación de Luma del sistema eléctrico, incluyendo los presupuestos iniciales, y que también se ha suministrado y está disponible una versión en español de la petición para aprobación de los términos de servicio que de la cual vamos a hablar hoy. I'll begin in English now. Good morning, Mr. Chairman, commissioners, staff, and consultants. Welcome to members of the public that are watching these proceedings on the Energy Bureau's YouTube channel. Thank you for this opportunity to address the Energy Bureau on the subject of the proposed terms of service. My name is Mario Hurtado. I am Vice President for Luma Energy. I'm appearing today on behalf of Luma Energy Servco LLC and Luma Energy LLC as Management Co. in support of and to request approval by this Puerto Rico Energy Bureau of Luma's request for approval of the terms of service. This has been referred to as a petition for approval of the terms of service. And this is in accordance with section 4.1G of the Puerto Rico Transmission, Distribution, Operation, and Maintenance Agreement, effective June 22nd, 2020, which we commonly refer to as the OMA. I appear to support the request to include the OMA terms of service in Prepa's tariff book approved by the PREB, the Energy Bureau, by resolution and order issued on May 28th, 2019, in case number CEPR-AP 2015-001. And then I have also in CEPR-AP 2018-003, the tariff book resolution in order. First, I'd like to start by giving a bit of background on the purpose of the terms of service that were agreed upon in the Operation and Maintenance Agreement. The terms of service were included as a necessary component of Luma's ability to stabilize, recover, and transform the operations of Puerto Rico's transmission distribution system. As both the Puerto Rico legislature and this Bureau have recognized, the T&D system is plagued with a neglected and unreliable infrastructure. The utility has ineffective management processes, and the T&D system is in a state of disrepair due to damage from Hurricane Maria and lack of maintenance and capital investments. Luma has provided in the dockets for the initial budgets and the system remediation plan specific detail on Luma's assessment carried out during the front-end transition of the utility processes and the assets. The terms of service are an essential component of Luma's ability to remediate the system, while at the same time providing customers with efficient and reliable electric service within the approved revenue requirement for the electric base rate and without the need to increase rates to customers. Part of the purpose of the transformation of the electric sector is to bring the Puerto Rico utility to utility industry norms in the delivery of service. The parties to the OMA considered that the terms of service should include waivers of economic liabilities that are standard for North American utilities, as explained in the petition for the approval of the terms of service, and as Mr. Branko Terzic, Luma's independent expert witness, will further explain. Another important consideration for the parties was the risk of occurrence of major catastrophic events that could affect the utility's ability to render services, and that in the absence of the terms of service could expose Prepa as asset owner and Luma as operator to substantial claims for relief that could threaten the ability to provide an essential public service. The proposed terms of service will also ensure reasonable and equitable treatment to all classes of customers. The purposes of the proposed terms of service include a few that I will mention now. First, to prevent increases in utility costs, ensure predictable, fair, and reasonable treatment of customers, and mitigate the risks resulting from the obligation to provide services to all customers, regardless of the potential liability they may pose. Second, to help guarantee that the cost of electric power service in Puerto Rico is affordable, just, reasonable, and consistent with sound fiscal and operational practices that provide for reliable and adequate service. Third, to protect Prepa and Luma from catastrophic losses that may occur in the event of service disruptions or malfunctions or damage to the electrical system caused, for example, by atmospheric events such as hurricanes, to which Puerto Rico is especially prone, and that with the presence of climate change may pose a higher risk than historically has been the case. Fourth, to put the utility in an improved position when negotiating insurance coverage prospectively, having terms of service that include waiver of economic liabilities, as most utilities have, will improve the utility's financial risk and enable an improved position when it comes to negotiating terms and rates for insurance. I'd like to stress that the proposed terms of service are not intended to limit the protections or the processes currently established by the Energy Bureau, including the functions of the Office of the Independent Consumer Protection Office to protect customers. The terms of service do not displace protections afforded to customers by the Energy Bureau. The terms of service preserve the Puerto Rico Energy Bureau's authority to exercise oversight over the electric sector in general, and Prepa and Luma in particular. The terms of service will not alter the heavily regulated nature of Luma's operations or PREP's oversight of these operations. Luma will remain accountable to the Energy Bureau and its customers for compliance with the Puerto Rico Energy Public Policy and regulatory framework, as well as all legal and regulatory requirements applicable to electric power service companies. It is the highly regulated nature of Prepa as a utility and Luma as the operator of the T&D system that allows the Energy Bureau to approve limitations on liabilities, such as those included in the terms of service. Examples of the regulations on Luma's activities as operator of the T&D system that will remain if the terms of service are approved are following. Under Act 17 of 2019, Luma will be required to meet specified requirements and standards for the reconstruction and modernization of the T&D system to render it robust, resilient, and stable. In this regard, the Energy Bureau will approve and oversee implementation of Luma's system remediation plan, as well as implementation of capital improvement programs and other programs included in Luma's initial budgets. Luma is also subject to the Energy Bureau's oversight with respect to the implementation of various provisions of the Operation and Maintenance Agreement, including the establishment of the performance metrics and the system operation principles. Luma has specific obligations under the OMA to provide operation and maintenance services in accordance with contract standards that include the terms, conditions, method, techniques, practices, and standards imposed or required by applicable law, prudent utility practice, and applicable equipment manufacturer specifications and reasonable recommendations, among others. Finally, many of the programs proposed in Luma's initial budgets, some of which are also programs within Luma's system remediation plan, will establish internal controls, policies, procedures, or other measures to protect customers from risks related to the T&D system that could result in the potential liability that the terms of service seek to address. I think we provided additional information on this topic in the request for information 0006 in this docket. As stated in the initial budgets filing, case number 2021-0004, and in their response to request for information number 001 to this docket, Luma's initial budgets were developed assuming that the terms of service are approved by the PREP. The proposed terms of service do not require a revision of the revenue requirement, as I've said, and do not require a change in the rates that customers will pay. I request before this Energy Bureau that you consider the arguments set forth in the terms of service petition that was filed on February 24th as Exhibit 2 to the petition for approval of Luma's initial budgets, and we are available to answer all questions. Mr. Branko Terzic, an independent expert in utility regulation, will offer a summary of his opinion and will also be available to answer questions from commissioners and Bureau consultants.
Do you want to proceed?
Margarita Mercado, counsel for Luma. With leave from the Bureau, Mr. Branko Terzic will proceed with his summation of his opinion.
Thank you, Attorney Mercado. Yes, please proceed.
Good morning to the honorable members of the Puerto Rico Energy Bureau and the participants in this proceeding. My name is Branko Terzic. I'm a consultant holding the position of managing director with my firm, Branko Terzic and Associates, Inc. I'm also a senior fellow at the Atlantic Council and a distinguished fellow at the Council on Competitiveness. I have a Bachelor of Science degree in energy engineering and was awarded an honorary Doctor of Sciences in engineering, both of them from the University of Wisconsin in Milwaukee. During my 5-decade career in the regulated electric utility industry, I have been a consultant, a state and federal regulator, and the chairman, president, and CEO of a state-regulated public utility. As a regulator, I was first a commissioner on the state of Wisconsin Public Service Commission from 1981 to December 86. Then I was chairman of the state of Wisconsin Racing Board from 87 to 90, and later I was a commissioner on the Federal Energy Regulatory Commission 1990 to 1993. In my 5 years in service as a commissioner on the Wisconsin Public Service Commission, I regulated electric utilities, natural gas utilities, telephone and water utilities. The regulation by the Wisconsin PSC, of course, is at retail and included the establishment of rates, tariffs, and terms of service. We had about 700 utilities, about 600 of those were small municipal systems, and about 14 major utilities. The PSC at the time I was there, during a great period of inflation, handled about 100 rate cases a year. In my role as a commissioner on the Federal Energy Regulatory Commission, I dealt with wholesale electric markets. I've also served on a number of governmental advisory boards, being a member of the U.S. National Petroleum Council and the National Coal Council, and I served as the United States Department of Energy delegate and chairman of the United Nations Economic Commission for Europe ad hoc group of experts on cleaner electricity from 2007 to 2012. In the private sector in consulting, I was most recently executive director of the Center for Energy Solutions at Deloitte, and I held other positions at Deloitte during my 15 years there. Prior to that, I was chairman and president and CEO of Yankee Energy System, Inc., which at the time was the largest gas distribution company in Connecticut. I started my career as an engineer with the American Appraisal Company, later with Wisconsin Electric Power and AUS Consultants, all based in Milwaukee, Wisconsin, before being a commissioner. I've published numerous articles. I've given many speeches, all of which are listed in my CV, which is attached. I was a professional engineer in Wisconsin for about 25 years. I no longer hold a license, and I have provided training on utility regulation to utilities, regulatory agencies, academic institutions, international banking institutions, and consultancies as well. I have testified in the past before state public service commissions, in bankruptcy court, and before the Federal Energy Regulatory Commission. I would like to briefly highlight my experience in the regulation of public power utilities, such as Prepa. The state of Wisconsin, where I served as commissioner, is somewhat unique among state commissions in that the state legislature granted the Public Service Commission authority over all the public power systems in the state back in the 1920s. This is very unusual. Wisconsin now has about 81 municipally owned utilities. They are smaller systems, and they provide about 11% of the state's electricity and service in 41 of Wisconsin's 72 counties. As I mentioned, the State Commission also regulates water and sewer. The purpose of my testimony here before the Puerto Rico Energy Bureau is to support the approval of the terms of service requested by Prepa and Luma in their Exhibit 2, request for the approval of terms of service and memorandum in support thereof. It's my opinion that this board can approve the request for terms of service, making them applicable to all customers in Prepa's tariff book. I believe the requested terms of service are within the range of prudent public utility industry practices with respect to limitations and liability. My opinion, after research and analysis, and including taking into account my own 5 decades of experience as a regulator, utility executive, and consultant in the regulated industry, is based on the following 3 considerations. Number 1, a terms of service provision, which includes limits on economic liability of electric utilities due to service interruptions, deficient, irregular, imperfect service within filed rates, is universal in the U.S. for all investor-owned utilities and for public power entities such as Prepa as well. Secondly, the requested terms of service, I believe, are appropriate for Prepa and are in the public interest. And third, the terms of service are, as requested, is a necessary component of the initial budgets petition, and as such is a part of the package under contract standards, which include practices and standards commensurate with prudent utility practice. It is my understanding that the history of the current system has failed to produce public benefits of improved electric services in terms of, for example, lower outage or frequency. The FTI report entitled "The Advantages of Third-Party T&D Operator of the Puerto Rico Electric System," included in the Partnership Committee report, indicated that the Customer Average Interruption Duration Index, CADI, which is the average restoration time a customer may experience for Prepa, has been higher than target metrics, and that, quote, with the exception of 2008, CADI has experienced an upward trend over the past 7 years. This would imply that the current outages payment system has been ineffective or had no effect as a tool for the reduction of outages. I would also like to comment on the public interest that the regulators may consider in approving terms of service limiting economic liability. As I mentioned, these are universal in the US and Canada. The public interest may be understood with reference to the decision by the US Supreme Court in Munn versus Illinois that certain classes of private business can be regulated as to prices charged because these businesses were vested with the public interest. We have here, of course, the unique situation where Prepa is not a private business, and neither are the public power entities that I was regulating in Wisconsin, but are applying the same sort of public interest standards. These kinds of companies were called public utilities or public service companies, and the state agencies to regulate them in the United States were given the applicable and to regulate them under public interest standards were generally called public service commissions. While defining the public interest is a matter of subjective and state-by-state determination and interpretation, through decades, I think the commissions have simplified it to two major features. Number one, utility customers should have highly reliable service and pay only just and reasonable rates for that service. And number two, a prudent utility should be allowed an opportunity to earn a return on equity that allows it to be financially viable but not highly profitable. For governmental systems, that public interest will include allowing rates which secure the financial viability of the governmental service provider, as, for example, Your Own Energy Bureau's website indicates that that one of the functions is to guarantee that Prepa meets its obligations to bondholders. So that would fall within that. This regulatory analysis involves, among other things, decisions that reflect fairness for all the involved parties in the regulatory process and the commitment to the general good. Specifically, good regulation weighs legitimate interests and makes decisions based on facts with the goal of balancing the interests of all the various stakeholders. In my opinion, the requested terms of service is appropriate for Prepa in this case and is in the public interest. The requested terms of service will assist Prepa in meeting a number of its established Puerto Rico energy policy goals, including, I quote, to guarantee that the cost of service of electric power service in Puerto Rico be affordable, just, reasonable, and non-discriminatory for all consumers in Puerto Rico, end of quote, as stated in the Puerto Rico Energy Policy Act of 2019, and also that to ensure that the consumers in Puerto Rico, quote, receive reliable, stable, and excellent power service at a cost that is accessible, just, and reasonable. The new terms of service and accompanying performance indicators will release resources now spent on litigation to needed maintenance and investment in service quality. The reduction in payments from service losses will lower the cost of electric service to all Prepa consumers who otherwise would fund those payments in the form of higher rates. The omission of a volatile or hard to estimate liability payments will support the financial stability of Prepa. Legal, administrative, and technical resources now being required by the claims payment system could be diverted to activities that allow for greater efficiency and reliability in operation. The reduction in cost is of significant concern to the people of Puerto Rico as set forth in the Policy Act of 2019, which, for example, states that the rate shall not exceed or should be below 20 cents per kilowatt hour, while a May 15th, 2020 partnership report, Puerto Rico Public-Private Partnership, indicates that Prepa's average cost per kilowatt hour was 19 cents in 2016. So there is pressure, obviously, there. One of the few tools available to regulators to reduce cost to utility, which is mostly subject to market prices for labor, material, and service, is in this case adopting a more restricted limitation or adopting a limitations of liability in terms of service. It is important to stress, I believe, that the terms of service is an essential tool to protect Prepa, Luma, and the customers in the event of catastrophic losses. I support the approval of the preferred terms of service, including the limitation on gross negligence and willful misconduct. In my opinion, that restrictive limitation of liability can be supported in this instance due to a number of unique and negative circumstances. Under the operating and maintenance agreement, Luma Energy steps in to manage and operate a large and complex electric system, which it did not design, did not build, operate, did not train the workforce, nor maintain with its own crew. Thus, claims of economics losses in the future will most likely be the result of the accumulated problems inherent in the existing electric system, a system which Luma will contract to operate and improve in the future under your oversight. I should point out, of the many terms of services I reviewed, the entity most similar to Prepa is the British Columbia Hydro, the province of British Columbia's Crown Corporation, which is a government enterprise, but it's regulated by the British Columbia Utility Commission, and it does include these same provisions. The requested terms of service can be improved as part of the initial budget petition, which also includes a package of contract standards. The initial budget petition filed with the Bureau includes a significant new series of performance metrics defined as, quote, numeric indicators to measure how well Luma is performing in alignment with public policy and making tangible improvements for Puerto Rico. These new performance metrics will provide you an objective and ongoing tool for the Bureau as the regulator and for Prepa as the owner to monitor the performance of Luma as an operator. The goal, of course, is improvement in the reliability of Prepa services to customers. As I said earlier, payments for outages system now in place has failed to improve Prepa services up to this point in time. I believe the board has the Bureau to implement this. It is in the legal proceedings. I myself looked at the underlying documents, Section 3.4 of Act 57-214, the powers and duties of the Bureau, very similar, written to the state commission standards, which is generally the legislatures have put in an omnibus statement giving a blanket tremendous authority to commissions, which I've used myself. For example, in your case, paragraph RR says, I quote, all the additional implicit and incidental powers that are pertinent and necessary to enforce, carry out, perform, and exercise all the aforementioned powers and to achieve the purpose of this act, close quote. In summary, I recommend that the Bureau approve the requested terms of service because the limitations on liability for service interruptions, defective or irregular or failed services in connection with transmission and distribution of electric energy are A, the most common regulatory policy for electric utilities in the US and Canada, universal. B, is in the public interest, benefiting the greatest number of customers of Prepa, and it is included in the package of regulatory policies and requirements designed to incent efficiency, improve operation, and reduce costs to Prepa's customers. Thank you for your attention and the courtesy.
Thank you. Margarita Mercado, Counsel for Luma. Mr. Mario Hurtado would like to address You're fine.
That's fine.
Okay, so we can proceed with the questions, and we thank the Bureau for the opportunity for both Mr. Hurtado and Mr. Terzic to address initially the Bureau with their statements and opinion.
Thank you, Attorney Mercado. Before proceeding with questions from commissioners, I would like to ask Attorney Bolaños if she or Prepa representatives have any opening comments at this point.
Thank you, Engineer Acaron. No, we don't have any comments.
Thank you. And then we will proceed with the discussion, beginning with questions from the commissioners to Luma representatives and Prepa representatives.
Okay. Good morning, Mr. Hurtado. Good morning, Mr. Terzic. This is Commissioner Angel Rivera. First of all, thank you very much for being here today and for your testimony. And I think that we're going to have a very productive conversation in the next, I will say, several hours. I will make reference to your each of your pre-filed testimonies, and also want to be referencing to some extent the file submitted with the May 11, 2021 filing, which is like answers to the Energy Bureau's several questions that included some attachments. And I want to make sure that at least Mr. Hurtado had those files available to him.
I do, and if Commissioner, and if I don't, one of my colleagues will.
Okay, excellent. All right, excellent. I'm going to reference briefly some of the content on those files. And anyways, I want to start with you, Mr. Hurtado, if that's okay. I want to, first of all, normally the direct testimonies end with the question, does this conclude your testimony? Yours didn't have it. I want to make sure that the testimony that you presented is the extent of your testimony.
Thank you for the question, Commissioner. Yes, that was the extent of the summary of my testimony. Yes.
Okay, thank you. If we go to the answers of your question number 9, specifically on lines 72 to 81, it talks about how the proposed terms of service are a necessary component for Luma's ability to stabilize and to restore the electric system. Can you describe how the terms of service are a necessary component of Luma's ability to actually do that, stabilize or remediate the system? Can you expand a little bit on that?
Certainly, Commissioner. I'm just rereading the answer here, so make sure I answer your question. Commissioner, in answer to your question, I mean, I think that the answer that you're quoting kind of touches on these and does summarize or give the answers that, in my opinion, are the reasons why it is part of the recovery and transformation of the electric system. I think that the activities of Luma as the operator on behalf of Prepa, the utility, include obviously the provision of an essential public service. Luma has a duty that's passed on to it, or it's obligated to carry out as a provider of last resort as well. And it has a duty to treat all customers equitably without regards to the level of risk that those customers may pose to the company or to the utility. And it has the obligation to carry out these activities under all conditions, including emergency conditions, including hazard. And as we've covered, I think, in other dockets, as a system operator, Luma will have to make decisions, and its personnel will have to make decisions and take actions, which will include, in some cases, the limitation of that service. And that will involve clearly choices that will have consequences, which may have adverse results for specific customers. We still are obligated to make those decisions based on the overall interest of the system, our obligations under the contract, and the obviously the procedures that underlie those system operation principles. And we have to act in what, at the time, given the information that's available, is in the best interest overall of the system, I think is the way that we've talked about it in the context of the system operation principles. Yeah. So I think that this is a measure which reduces the risk for the utility and for Luma as its contractor and operator. And it is typical of electric utilities. And so in carrying out our duties to the norms and that are established in an approved utility fashion, we think it's appropriate that this risk mitigation measure also be part of the package because we think it is essential for that service.
Okay, I understand. So essentially, you see it as a tool to address risk and limit exposure for the based on the type of service that Luma and Prepa will be providing.
That's one of the main purposes, sir.
Okay, excellent. Thanks. Mr. Terzic, in his brief statement and throughout his testimony, essentially said that the liability waivers are universal, essentially, in every jurisdiction in the United States. It's just a matter of degree. And Mr. Terzic, I'll talk to you about the range that you addressed a little back. I'm going to talk to you about it in a bit. But like the chairman said, one of my major concerns, me personally, is the extent to which these specific liability waiver is being requested. Specifically with the gross negligence and willful misconduct language that we have in there. To that effect, I would like to reference lines 87 through 89 of your testimony, Mr. Hurtado. In there, you said that an important consideration for the parties was that the terms of service that include waivers of economic liabilities are standard for the United States utilities, as explained in the petition for approval of the terms of service. I'm gonna end it up there. So essentially, am I to understand that you agree with Mr. Terzic's statement that liability waivers are universal, if not very common, in the United States?
In my experience and from the knowledge I have, they are pretty much universal. I don't know of other examples, so I would say that that's right.
Okay. To the best of your knowledge, how many utilities or jurisdictions include waivers for gross negligence and/or willful misconduct?
I don't have a number for that, Commissioner. I know that there are several examples of ones that do. One of them is the one that Mr. Terzic cited for BC Hydro, but I don't have a number.
Okay. I know this is Mr. Terzic's testimony. There was a British Columbia Hydro. Is this, to your knowledge, is this an electric company or a water company?
It's an electric utility.
It's an electric utility. Thank you, Mr.
Large electric generation, transmission, and distribution system, very similar to Prepa.
Thank you,
owned by the government.
Thank you. And if you don't mind, Mr. Terzic, I'll ask this question now of you. Besides that example, can you state or name other examples of electric utilities that contain such language?
Yes, I can. It'll just take me a second to find the right document. We had a water accident this morning, so I have some documents that are a bit wet. I'll apologize for that. I had them under my water bottle. Could we go on for a second? I'll look for my document and maybe.
Yes, sir. If that's okay, I have some questions regarding this on my portion, on my questions to you, sir, and I'll give you all the time until we get to that point to answer that question. Mr. Hurtado went away. Mr. Hurtado, are you still with us?
Mario Hurtado, yes, Commissioner, I'm still here.
All right. Um, so essentially, Mr. Hurtado, just to recap what you just said, besides the British Columbia case or example that Mr. Terzic provided, you don't recall any other jurisdiction or any other utility that uses such a language?
That uses this specific language. I don't. I do think that it's appropriate for this specific case. In our work and in the assessment that we've done, we've also come up with evidence and provided it in the different dockets that the current performance and the current state of the utility here in Puerto Rico is literally at the bottom of all the North American utilities.
No, I understand. I'm sorry, go ahead, sir.
No, I was just going to add, in addition to performance, I mean, one that causes us great concern is specifically on safety. The performance is several degrees beyond the worst performing utilities. And that is indicative of an atmosphere in which there's very little process, if any, in which individuals act on their own judgment without necessarily any guidance or oversight, and in which there's actions taken on a regular basis which endanger the safety of employees and of the public. And to us, that's indicative of an overall culture that has a very, very high risk level. So we will be stepping into that. A substantial portion of Luma's employees will come from that culture and from that company. It's our duty to change that. I think we've talked quite a bit about how we will immediately start to do that with training. But it is one of the factors that we considered in thinking about what the appropriate terms of service would be.
I understand that, and you mentioned the state of the system, and everybody here probably is in agreement that the state of the system is not even optimal. You mentioned that it was pretty much on the bottom of probably every other jurisdiction in the United States, or close to the bottom. But this is my thing. Gross negligence and willful misconduct has little to do with the actual system. These are human factors that relates to the human conduct. And specifically, willful misconduct is intentional disregard of good and prudent standards, whereas gross negligence is a conscious and voluntary disregard of the need to use reasonable care, which is likely to cause foreseeable grave injury or harm. So essentially, we're talking about almost intentional misconduct from the part of the people that will operate the system. And the liability waiver doesn't only cover the employees or the line workers. It goes all the way to the directors, to Luma's upper management, to Prepa's upper management conduct. And those are people that the company have a direct supervision or impact or a direct control with regard to their conduct. So my question is, why is this reasonable under that specific premise?
Thank you for your question.
Let me, Commissioner, my apologies, I just found my notes. A District of Columbia and Massachusetts have gross negligence in a Massachusetts case, Maryland Casualty versus NStar Electric Company. The Massachusetts Supreme Court held that an approved tariff can limit a public utilities company's liability for consequential damages, including business losses that result from gross negligence. We'll provide that site to you. And there's also a District of Columbia case as well. There may be others. As I mentioned, it is in the British Columbia tariff. Once again, for a state-owned enterprise, we're not. These, of course, are investor-owned enterprises. Thank you.
Okay, I understand, and thank you for that, Mr. Terzic. The Massachusetts case, do you remember what year was it decided?
2015.
2015. Thank you.
Sorry, Attorney Mercado, if I may, the Massachusetts case, the Maryland case is cited at page 10 of the petition of terms of service for the benefit of us.
Yes, thank you. Broke the flow. Okay. So 2015. Okay, so the British Columbia tariffs currently have that provision, correct, Mr. Starsik?
Yes.
Is there any, Ms. Mercado, is there any way that Luma can provide that at a later date?
Yes.
Thank you. So, Mr. Hurtado, going back to my question regarding the control that Luma has over its directors and the upper management of the company and the direct control with regards to their actions, specifically towards the gross negligence and willful misconduct. My question was, how can this be considered reasonable under the premise that you just stated, that is the state of the system and the culture of the line workers or the people that are working, that will be working for Luma?
Commissioner, as I stated, I think the focus that we had for this as a risk mitigation measure and the reason for the way that we thought it was appropriate, or rather the reasons we think it is appropriate to the system is because of the human processes and the human element. Well, the physical element is important, but the human element. And so in our diligence and in the work that we did, obviously these terms of service were crafted before the front-end transition, but what we saw during the RFP process was confirmed, if not, in many cases, we found it to be much worse than we suspected from what we saw during the process, and did see multiple instances of intentional disregard for processes and safety conduct, and throughout the organization at multiple levels. As I stated, I think that is one of the main reasons why we think this is appropriate in this case.
May I?
Hold on, Mr. Starsik. I understand appropriate. My question was with regards to reasonableness.
I also think it's reasonable.
Thank you. Mr. Starsik.
Yes. Just to remind, the commission still has other tools and authority with respect to discipline, with respect to accountability for any of this kind of any gross negligence or misconduct. This merely limits the payment for economic loss. It does not limit the commission's ability to use its other tools, disciplinary tools, orders, sanctions, whatever, to make sure that the parties involved, whether it's at the manager or other level, are accountable. So this is not an escape from accountability for gross mismanagement. It is a limitation just on the payment of economic damages. The other tools are there, and I'm sure you would be very not reluctant to use them.
Okay. So, Mr. Hurtado, what you're saying is that, okay, so Mr. Hurtado, what you're saying is that, for example, in other proceedings, such as establishing performance metrics, you're saying that one way to induce performance is a system of rewards and penalties, not only rewards, but also penalties. When certain expectations are not achieved, or when certain actions are not being taken by the utility. Is that your statement, sir? Is that a tool that is available for the energy for any regulator to mitigate the other end of the spectrum, which is a completely unliable utility that has no incentive to perform?
If I understand your question, Commissioner, the terms of service are specific to third-party claims in civil courts. They would not limit the authority of the commission, of the Bureau, to regulate to regulate Prepa or Luma.
You know, that wasn't my question regarding. My question was more geared towards: is it appropriate to use that type of tools as incentive to induce performance? When I say tools, is penalties and rewards.
I believe the performance metrics, both in regulation and as they are in draft form and proposed, were part of what was in the operation and maintenance agreement, and we did think it was appropriate to have those as part of the package of tools that the regulator would be using in regulating Luma.
Okay. Thanks. Mr. Terzic, to the best of your knowledge, under what circumstances was British Columbia allowed? Let me rephrase that. Under what circumstances the terms of service for the British Columbia company that you just mentioned were approved, that were essentially waived for gross negligence and willful misconduct? What were the conditions, or what was the state of the system? What was essentially the circumstances that led to that, to your knowledge?
I do, Commissioner, that's an excellent question. I don't know the history, but the question underlying that question is a very important point, which is that every jurisdiction will have its own history. The various states' courts have interpreted differently. Even one generation of court within a state interpreting differently from a previous court generation I have seen. Secondly, there'll be factors such as recent weather developments. Much of the literature that you'll find about outages and liability was written after the derecho of 2012, where a large number of states were affected by power outages who before that didn't really experience very many outages. And so there are many questions by consumers. What are my rights? What are my payments? Is the current system fair? So that each state has its own unique history. I'll mention the recent Texas experience. If you Google outages and Google payments, you will see that there's a lot of interest in Texas after the January crisis, where people are asking, well, who gets paid for what are my rights, which didn't appear before that. And so state regulators and commissions frequently will relook based on current performance, based on current activities, whether the terms and liabilities should be changed. In this case, we're not talking about a change, we're talking about installing some limitations on liability. In every other case, they're talking about modifying, changing, etc. So much of the activity in this area is stimulated by natural disasters that occur and where people question what is the old system. It doesn't mean the regulators will change the system, but as you're pointing out, there may have been unique factors in British Columbia which led them to put this in. It is, for example, not the case in the other provinces. Ontario, which has the Ontario Energy Board, but once again, different weather, different history, different political factors, different provincial law, all may have led to that difference.
Okay, I understand. And in lines 87 to 89 of your testimony, Mr. Terzic, you discussed that let me find it. Okay.
Did you want me to comment on it, Commissioner?
Yes, essentially what you're saying is that the terms of service, I wanted to have the text in front of me. You mentioned that the text, that the terms of service, the proposed terms of service are within the range of public utility industry. Can you describe that range? You have mentioned that in several times. Can you describe what we're talking about?
Sure. We have the wonderful instance here where the range is, there is no limitation.
There's no limitation, okay? That's one of the...
It's the only place I'm aware of, and I looked at 38 or 40 states where there was no limitation on terms of service, but universally there are the acts of God and weather are included in almost every one that I've read. So at a minimum, it would be acts of God, weather, government action, government requirements, for example, rotating blackouts required to protect the system. This happened in Texas, where they had to rotate blackouts in order to keep the entire system from collapsing. That was done by the utility, but approved by the regulator, as would be the case here. I cannot imagine that Prepa would do a rotating blackout without approval of the regulator. So these are the kinds of actions that are in the limitations of liability and are natural and seem to me to be appropriate. So we do have British Columbia and another of Massachusetts and a few other places that have this very, very restrictive language. We have other places that don't. I think my testimony is that the unique circumstances here with coming into operating a system that is stressed, has had problems, that is the rationale why I believe both the Prepa, the partnership and Luma and other bidders requested and insisted that this kind of language be in there.
Okay, yeah, and I understand all that. So essentially, the range of action goes from no limitation to what is being presented here. So it is basically, are we to assume that the liability waiver that was proposed, is that on the other side of the spectrum? Essentially, is that on the high end of that range that you were discussing?
In a common, I guess under common English language, at the high end, at the more restrictive end, where yes, it is more restrictive. But once again, I think there's circumstances here argue for that, and clearly it is the belief of Prepa, which has signed the OMA with this provision in it, and the public-private partnership and Luma, that collectively they believe they've requested that the Bureau approve this. They believe it's in the best interest of the system.
No, I understand. And you mentioned the OMA. The actual clause on the OMA is that the parties agreed that Luma was going to request an approval of this language. It's not that that is the actual language on that clause. You know, the agreement was to present these for approval on the Energy Bureau, and you know, we can discuss the language later on, but I just want to clarify that. On lines 125 to 127 of your testimony, Mr. Terzic, you said that in both cases, public ownership and in investor-owned utilities ownership, prudent utility practice has dictated that some form of limitation on liability be incorporated in tariffs. So essentially, this goes to your universal statement that, you know, some kind of liability restriction or limitation should be included or could be included as the best practices dictate. My question is, if the language pertaining gross negligence and willful misconduct is removed from the proposed terms of service, will the terms of service still fall within the range of public utility industry practice with regards to limitation of liability that you discussed earlier?
If that language isn't in there, it will look like the language in other states, in some other states, and some other jurisdictions. And the question, of course, is, should it look like those, or should it look like the requested terms? So
Yeah, no, yeah, but
Yes, it will.
I understand what you're saying. My question. You answer it. You answer in a very interesting way. My question is, if that language is removed, will it still be within the range or the standard? Well, the standard, because like you said, every jurisdiction is unique. But will it look like? So you're saying that it will look like other jurisdictions if that language is removed? Okay, is that more common, the language with these two phrases removed, than the ones that have gross negligence and willful misconduct? Which one is more common?
Yes, it may be more common, but I doubt this commission or any commission would want to premise its decisions on what is common.
No, we're not. I'm just
trying. I would urge caution that it might be common, but this commission would not use a common return on equity. It wouldn't use a common depreciation rate. It wouldn't use a common O&M expense. It would use what is appropriate, factually developed, and what the policy is of this commission. So it could look like an average, but I would never recommend to a commission that their standard of regulatory policy be that they do what's average.
And that is not my statement or the way that I'm going towards. I'm just trying to ascertain how it is managed in all the jurisdictions. Because you were a regulator in Wisconsin, and sometimes unless we go to NARUC every year and talk to other regulators, we think that ours is the only jurisdiction in the face of the earth. But what I have learned in the last 7 years as a regulator here in Puerto Rico is that it is also good to look what other jurisdictions are doing. And I agree with you that we cannot regulate in a commonality, but we can regulate on similarities. And that's why I was asking what were the underlying circumstances of British Columbia. Since we don't have them, it's very different. It's very difficult to ascertain on how do we compare. So we have to start looking in other jurisdictions. So I'm trying to do the exercise of not thinking that Prepa is the only utility on the face of the earth. So in that sense, you will say that it's not as common based on the circumstances. So that could round it up, right? Okay. You in the lines, I believe, lines 137 to 138.
Commissioner Rivera,
Yes.
if you allow, can I?
Yeah, go ahead.
Yes. Can you explain how the public interest is best served with the gross negligence or willful misconduct? If we leave these two phrases in the clause, can you explain that in Puerto Rico, how the public interest is best served?
Yes, keep in mind, we're only talking here about the economic payments or loss of service due to those factors, and the payments would be lower with the inclusion of this possibly with the inclusion of this language. One of the benefits I have in speaking to you is I'm not a lawyer, and so it's going to be a little difficult for me to maybe address this more carefully. But my understanding, it is very difficult to prove gross negligence. I'll leave it to individual courts and individual states. But because purely on the basis that it will limit the claims, that will lower the future risk and the future payments that citizens of Puerto Rico will have to pay through the flow through of these liability payments under your regulatory system as a cost of service.
Okay. Mr. Terzic, I had another question on the previous line, but now that you answer that, or now that was part of your statement now, in the last year, in the last 10 years, how much has Prepa from their own pocket paid? Not how many claims or how much claims there has been. How much money are we talking about? How much money has Prepa paid in the last 10 years regarding payments for claims and lawsuits?
I don't, the company, Prepa has those numbers. I believe they were difficult to get. I believe that Mr. Hurtado may have those numbers, but keep in mind, we're looking prospectively. Rate making is prospective, and you are going to be looking ahead with a number of change factors. Number one, we're hopeful that Prepa will come out of bankruptcy, and there may have been a suppression of cases of filings because of the bankruptcy. Number two, we're talking about the potential liability in the future of major hurricane storms, which by general, I think, consensus will increase due to climate change factors. And so we're looking ahead to avoid an unknown number. I'm not sure the recent history under bankruptcy would be characteristic or average, but the company has its own numbers. The total amount is quite large. That is, my understanding, it's over $1 billion, but I don't have the detail, the year-by-year breakdowns.
Okay, understand. Claim, a couple of things. Number one, claims is different than payments, right? You know, essentially there is a percentage that normally doesn't get paid or get lost on the way or whatever. Second, I agree with you. Rate making is prospectively. Essentially, we are doing towards the future. But in order to ascertain future risks, the only data that we have is the historical one. So, you know, we can sit down and extrapolate that historical one towards the known and measurable changes that are going to happen in the next 5 or let's say 15 years, just to choose a random number. And we can ascertain that risk, and we can sit down and crunch the numbers. I'm also an engineer. I love crunching numbers from now until eternity, rather than ask questions to witness. Anyways, that's something that we can do. But in order to ascertain that future risk or probabilities, we need to go and look into the past, and that's why I went back 10 years, because you know the bankruptcy is about 4 years, almost 5 years long. So you know it's something to look at. Okay, and I understand that you don't have the data. On lines 137 to 138 of your, moving on to the next point.
Sure.
Yeah, go ahead.
Yes, I reply. We do know one certainty, and that certainty is that the number, whatever it is, will be lower with a limit on liability and discharge of service than otherwise.
It's a matter of degrees. I agree 100% with you, and that's what we're discussing here. So okay. You said in line 137 to 138.
Rivera, going back, if you allow me, going back to your answer, and then what is Luma? I mean, how can we be sure that Luma stop being negligent? I mean, or gross negligent if they are exempt of responsibility? I mean, this is the other side of the coin. I mean, how we strive for a balance?
Mr. Chairman, is that question for Mr. Turstick or?
Yes.
I'm sorry, Mr. Chairman. I'm an old artillery officer, and my hearing isn't perfect. Would you repeat the question, please?
Yes, because going back to your answer, you say that this is economic and whatever, and then going back to the other side of the coin, we also want that not wrongful negligence or willful conduct. So if we exempt Luma and we approve these clauses, how can we be sure that you strive for a balance in your operation of the grid?
Yes, Mr. Chairman, because you have all of the other metrics and tools. You will have a complaint process that even if there is not a economic liability, you will get a complaint from consumers about inadequate service. That whatever that commission, whatever happened under that gross negligence, even if there's no payment for economic damages, you will have a complaint. Your engineers will be aware of it. You will investigate it, and you will have metrics and other things by which to use your regulatory authority. So nobody's getting away with anything here. We're merely talking about the economic payment to third parties. We're not talking about any ability of the utility to escape from its responsibility to provide adequate service. And so gross negligence would be dealt with through your other regulatory means. It would not be purely an economic payment to some third party. That's all we're talking about here.
Mr. Chairman, if I may I add to that? This is my
Go ahead.
So I think just to emphasize one point made by Mr. Tursick, our view and just writing in the terms of service is that Prepa is best positioned to weigh those penalties if they exist, including for gross negligence, and the overall impact it would have on on rates and customers. This is not. We're not seeking an absolution of responsibility for Prepa or for Luma. The waiver is specific to damages from third-party suits in civil courts. And further, if I might, in terms of the distinction between, I guess, gross and ordinary negligence, I'll repeat something Mr. Tursick said. I'm not an attorney, but my understanding from what I've read to prepare for this and the material that I've reviewed, there's a fair amount of there can be a fair amount of debate in that distinction between, and depending on the jurisdiction, it can be quite lengthy and involve lots of time in the courts, distinguishing between what is gross negligence and what is, I think, termed ordinary negligence. And so the inclusion of gross negligence in the language here, I think, also means to address that as a risk, the cost and the time, and again, in the third-party courts. The third thing I would say is that we certainly will be Luma. As the operator, will certainly have responsibility to carry out its duties and to exercise, due care. And we will have, a code of ethics that all employees have to abide by. They have to actually attest to, and that violation of that is grounds for dismissal, and managers will be held responsible to that. So that's one of multiple controls that we will be putting in place in order to improve the processes and improve the overall performance and make sure that we are taking due care in our duties. So again, we're not seeking an absolution or we're talking about a very specific waiver.
Okay. Yeah, thank you, Mr. Hurtado. And I do have some line of questions regarding the level of rate impact that we are talking about. Luma and Mr. Tursick both have mentioned. Well, not specific words, I'm just paraphrasing, the rate impact that it will have, essentially increased rates. And we've been, you discussed that. And I do have several questions regarding that. And that's why, my initial questions about how much payment, claims are claims, how much payment have been made in the past is what is going to go into the rates. And that is something that I would like to discuss with you, Mr. Hurtado, later on. But Mr. Tursick, back to lines 137 and 138, the famous lines that I repeated like 3 times already. The requested terms of service, you said, are appropriate for Prepa and are in the public interest. My question, will your conclusion change if the language pertaining gross negligence and willful misconduct is removed from the proposed terms of service? In other words, will the terms of service still be appropriate for Prepa if that language was not there?
I think the language that was proposed is the most appropriate for Prepa, and it meets, it is in the public interest. That does not preclude the fact that some other language might be in the public interest as well. It merely is that this language, I believe, is in the public interest and can be supported from that. It is not exclusive.
Okay, understand that in your opinion is the most appropriate. And, you know, in administrative law, you know, with the regulator has to reach a reasonable decision, not necessarily the best decision. My question is, will it still, it's not going to be most appropriate, but will it still be appropriate based on the fact that we have a range and based on the fact that some liability waiver it's normally included? Will it still be appropriate if those two terms or those two statements are removed from the proposed terms of service?
This is Attorney Mercado. For the record, I appreciate the question. I want to state for the record that it includes a hypothetical. He is an expert, and he can proceed to answer your question. But just to restate that his opinion is based on the liability waiver terms of service that was presented. But yeah.
Okay, Attorney Mercado, thank you very much for the clarification. And I understand that his opinion and his statement and his recommendation is to be included. My question as an expert in the field that is here to provide essentially his knowledge of about 50 years in regulatory matters. The question is, will it still be appropriate? I understand it will not be probably a recommendation, but will it still be appropriate?
Well, I'm not sure the definition for appropriate. The package that's asked for, I believe, best meets the facts and circumstances in this case. It is, I believe, the right answer in the case of a utility that's been struggling to provide and has failed to provide, according to the people of Puerto Rico, adequate, reliable, and cost-effective service. This package seems to me to be in line with the facts and circumstances as presented by the three parties involved, Prepa, the partnership, and Luma. So a different decision can be reached based on your understanding of the facts and circumstances. It would be appropriate for you to reach whatever decision you wish to reach, interpreting the facts and circumstances. My review of the, if you will, record of the facts and circumstances is that this package would be the appropriate, the most correct one, given the circumstances here.
Understand. So what I take from your answer, sir, is that the package proposed is the most appropriate, but with the language removed, it will be appropriate. Question mark. With all the caveats that you included in your answer.
With a loose understanding of appropriateness, this commission has the authority to make a decision based on the facts. Parties that later believe the commission has erred, I think, have appeal rights, and so not sure how I would characterize it as appropriate or not, but certainly the commission could reach a separate conclusion from my recommendation, and it would be their conclusion. It would just differ from my recommendation.
Understand. And can the same goals be achieved with a less restrictive language?
I don't know the answer to that, Commissioner. I don't know I don't know the frequency of the various components that will occur in the future. I don't know the frequency of which storms will occur. I don't know the frequency of which other factors limiting service could occur, as I don't know the frequency of which gross negligence would come up. So I just can't answer the question.
Okay. Thank you. Okay. Thank you for that discussion. That has been very helpful and, in my opinion, productive. Mr. Hurtado, let's go back to your testimony. And it's very interesting. I have, well, anyways, I'm not going to go there. Going back to your testimony, on lines 95 to 98, you stated that the proposed terms of service were adopted to ensure that Prepa and Luma do not incur in liabilities arising from individual customers' civil claims for compensation that will lead to increased costs that will be reflected in customer rates or could render the utility unable to operate. Rendering the utility unable to operate is a very interesting statement. Prepa currently does not have a liability waiver. Essentially, like Mr. Terzic said, they have a payment system. I believe is the way that he describes it in his testimony. We'll talk with him a little in a little while. Has Prepa been unable to operate due to lawsuits and claims?
To your question specifically, not to my knowledge. I think that I think that'd be more appropriate to say unable to operate effectively.
So unable to operate effectively. So essentially, it's a degree.
I'm not. So again, it's a hypothetical, but whether it would be unable to operate at all, I don't know, and that would be kind of the extreme case. I think that you pointed out a statement that probably requires a bit of an adjective or adverb.
Okay, I understand. Can you then clarify that statement, sir? Because essentially, unable to operate, from the engineering point of view, is that it will not function. It will come to a standstill.
Right.
So can you clarify your statement then?
I think my statement is that it will be unable to operate effectively to the terms and conditions that it's required to do so. Whether it would be unable to operate completely, I think I'd have a hard time saying, in my opinion.
Okay, thanks. Based on that, what is the current impact? What is the current rate impact due to payments to cover lawsuits and claims? Same question that I asked Mr. Terzic back then. How much has Prepa paid in the last 10 years with regards to lawsuits and claims?
Yeah, I don't have the exact number in front of me, Commissioner. Sorry, this is Mario Hurtado for Luma. I think in recent years, we're talking about millions of dollars to maybe tens of millions. So in the scheme of the whole thing, that's my understanding, subject to check.
Subject to verification. Okay.
Yes, sir. But I think, if I may, I think we've talked about this as a risk mitigation tool, and certainly it is prospective and forward-looking. And our prospective and forward-looking basis, the largest concern is over an unbounded risk or a catastrophic loss. And for a utility that has revenues totaling around $3 billion a year, it's not unreasonable to think that you'd have billion-dollar or multi-billion-dollar awards on a large third-party civil claim, especially
how many billion dollars claims have been filed against Prepa in the last 10 years?
I'm not aware of any, Mr. Commissioner, but again, our concern is prospectively forward-looking. We think that there will be changes in the condition of Prepa. Prepa is currently in Title III, as we've mentioned. Prepa will be coming out of Title III. Prepa now is operating under a different operating structure than it has historically. And, you know, there's an accelerated, there's a list of accelerated activities that are required for Prepa through its operator to undertake. And so we think it's reasonable that the conditions in the future, it's not unreasonable to think that conditions in the future would, you know, could pose that kind of a risk. And based on what has been seen in the U.S. utility industry, there are certainly cases where multi-billion-dollar awards have happened and where it's threatened the financial health and the continuing service from electric utilities.
No, I understand the concern on the forward-looking portion, but this is where I'm confused. Part of the basis of your request regarding the language is that you're going to be using the same Prepa personnel, is the same system. Essentially, the only difference is that now we have let me rephrase that. The first immediate difference is that now we have a private operator of the system. But essentially, especially in the first several years, it's going to be the same force that you said that is completely unreliable. Let me rephrase that. That you said that, you know, will expose.
Sorry, Mr. Commissioner.
I apologize. I apologize for the mischaracterization of your testimony. Let me rephrase that. Is the same force that poses the risk that requires the willful misconduct and the gross negligence language in the request. So operating with that force, operating that system, providing that service, Luma is here to improve upon that. So essentially, we're expecting a better service, a better system, less opportunities for claims. So the forward-looking risk has to take into account the system remediation plan, all the investments that Luma is putting in there, right? Because we're forward-looking, and Luma is here and is being characterizing that the service is going to be better, everything is going to be improved. Again, it's not a magic wand. You're going to do it over a period of 15 years. So forward-looking, under those circumstances, one might expect that claims due to unreliable service, damage, or why not, will be at least the same, if not less. And until now, Prepa has not had a multi-billion-dollar lawsuits in their hands. So my question is, what is the basis of thinking that prospectively we will have them? Under those circumstances that I just described it, and the implementation of the system remediation plan, the implementation of the system improvements that Luma is bringing to the table.
So, Mr. Commissioner, if I can try to address your question, I think that, again, the largest portion, and certainly one of the primary reasons that we think that this waiver limiting the damages from third-party civil courts is appropriate is precisely because it's hard to foretell the future. And it is reasonable to see a situation in which you do have catastrophic losses, third-party civil claims, which are very large in relation to the utility. And I think if we look at other cases, there are certainly cases of existing utilities with better operating histories, and of course each circumstance is unique. But those utilities, have been subject to very large claims, and relative to their enterprise size. So, my view is that it is very reasonable to think that is very much within the realm of possibility for Prepa going forward, in the absence of a waiver like this that limits the liability in front of the third-party courts.
Understand the most catastrophic event in the recent years, the recent history of Puerto Rico, I can tell you about two, and I've been the regulator for both. It was the hurricanes Irma and Maria in 2017, and the earthquakes of January of 2020. Those are the most recent catastrophic events that has happened to the electric service, to the electric system. And with the hurricanes, as you know, a significant portion of the population was without electricity for over a year. And I know that we're working, and Luma will be working towards remediate that. But my question is, those are the most catastrophic events. And let's say that we have one that is even more catastrophic than that in the future. How many lawsuits out of the hurricanes and out of the earthquakes have been filed for claims? How many multi-million lawsuits have been filed?
My information is that the total number, well, let me put it a different way. I don't know the total number of claims, Mr. Commissioner. The amount of the claims that have been paid out, as I mentioned, are not that big in relation to the size of Prepa. And we also, and I think it is also important to keep in mind that Prepa was under bankruptcy protection during Hurricane Maria, and its financial condition was well known. And in the future, it will be in a different situation. And in fact, this P&D system O&M agreement is one of the elements that changes the characteristics of the system going forward. And under those circumstances, we think it's reasonable to think that there is a possible catastrophic loss that would threaten the ability of the utility to render service at the contract standards.
Understand that. And I have one more question before I move on to my next line. How is that catastrophic event relate to gross negligence and willful misconduct? It's an event. It's an act of God or an act of a higher power, if you may. How does that relate to gross negligence and willful misconduct?
I think it's because in my estimation, again, I'm not a legal expert or an attorney, but certainly one could think of a claim in which the focus is on the actions of individuals or of specific parts of the company, the actions they undertook specifically either during or even after such an occurrence. And it's easy to think of circumstances in which those sort of suits would be launched in the absence of some sort of a limitation of those claims that could be made in a third-party court. Again, this is not something that would take away from the PREB's ability to regulate and order PREB and Luma to take actions, to be penalized, to redress potential damages that could happen to customers. This is focused on third-party suits in civil courts.
Understand. Thank you. And again, gross negligence has a foreseeable event and failure to act upon, and willful misconduct has an intentional element to it. Both of them are human-related instances and not due to catastrophic events.
Commissioner, I do think that I think one of the key elements is that it's not clear that the distinction between gross negligence and ordinary negligence is something that's clear in the courts and is customarily, well, let me put it a different way. It's certainly reasonable to think that the sort of distinction between ordinary negligence and gross negligence would be a highly contentious issue and one for which there's not necessarily a lot of case history.
Understand. Thanks. I want to make reference to an Excel file that was submitted on May 11, 2021. Sorry, I wasn't here in 2011. It's the attachment 3 to Prep 001.
Attachment 300. Yeah, I have it.
Let me know, please, when you have it.
I can see it.
Attachment 1, attachment 2. Okay, have it in front of me now, Commissioner.
It's attachment 3, right? On Excel line 1 of that attachment, I'm sorry, it's labeled in Spanish. Casos identificados como reclamaciones activas y cerradas, registradas desde 2009 al presente. So essentially, roughly translates to identify cases as claims, active and closed, registered since 2009 to the present. Is that a fair statement on what this file represents?
Yes, that is the title for the file, for that sheet. Yes, it's just one sheet in the file. Yes, sir.
Yes, one sheet on the file, and in the bottom, the title of the sheet is reclamaciones, which essentially is claims.
Correct.
Yeah.
Okay. Can you describe columns P as in Papa and Q as in Quebec?
Those columns are labeled cantidad reclamada, which would be amount of claim, I think, and cantidad pagada, which would be amount paid.
Okay.
I think, translation.
Thank you. And column R, it's fecha cerrado. What does that mean?
I think the translation for that would be date closed.
Date closed. Okay. So essentially, this has every claim for damage to property, falls, other claims, or why not, that Prepa has had since 2009 to the present. Is that correct?
This is Attorney Mercado. For the record, I just want to clarify that this is a document produced by Prepa, not prepared by Luma. So it's kept and maintained by Prepa. It was produced as their claims inventory within the dates covered in but it's not a document prepared or maintained by Luma or by Mr. Hurtado.
Understand, but it was Luma, the one that filed the document. So I understand with the caveat that it's maintained by Prepa. I just want to verify or clarify that what you received, let me rephrase that. How do you get this, Mr. Hurtado, how did Luma get this file?
We submitted a request to Prepa for it, and they supplied it to us.
Do you remember what was the actual request? You can paraphrase if you don't have the actual text on the request with you.
I don't have the actual request. The general activity that we were undertaking was to gather information on the history of claims that Prepa had experienced and had paid over the last 10 years.
Okay, so based on the title and based on the information presented here, and I understand that the caveat is that Prepa was the one that prepared this document, not Luma. Is it fair to conclude that these are the claims that we're talking about? You know, the monetary claims about third parties against Prepa.
This is the information that we were able to obtain from Prepa with information about their history of claims. That's what I'd be prepared to say.
Okay, thank you. Subject to verification, which can be done by, adding the column. If we add all the claims on the last 10 years that was provided by Prepa, subject to verification, would you say that that number is roughly $460.5 million?
Sorry, you're adding column.
Column P as in Papa.
The total on line 1,124 or 1124 is $460 million, roughly speaking.
Roughly speaking, $460 million. Now, if you do the same exercise for column Q as in Quebec, how much money has Prepa paid out of those $460 million over the last 10 years?
So column Q, the total for column Q is $988 million, roughly.
So out of, yeah, go ahead.
No, that's it, sir.
Okay, so out of $460 million that have been filed, Prepa has paid $988,000. On column R, which is closed, right? Essentially, it's difficult to ascertain. I didn't have the time to sit down and write the formula, but just by looking at the column, most of these claims, I will say the great majority of it have been closed. Is that a fair statement?
I'm sorry.
Closed.
Column R says the date that the claim was closed. Essentially, the claim is done. And
yeah, I'm not sure if this has. Yeah, I don't know enough about this table to.
Okay.
It has all of the claims, including the ones that are still open, because the ones that it appears that the ones that don't have a date on them are all zero, which wouldn't indicate that it has the current claims and the amount of current claims. So again, this is one piece of information that we've received from Prepa about historical payments for certain claims.
Understand, and part of ascertaining the risk towards the future is looking what the historical has been. And in the last 10 years, Prepa has paid roughly $988,000 out of $460 million that have been claimed. I'm just gonna say that is the proportion that this document that Prepa prepared and Luma submitted to the Energy Bureau says. Question mark.
Attorney Mercado, subject to verification and to the caveat that Luma has not had the opportunity to independently verify the information. It was an inventory provided by Prepa.
Understand. Thank you.
Yeah, yeah, I would agree with my attorney's comment.
Okay.
Excuse me.
I will have agree with my attorney as well. So understand.
I think that the other comment that's relevant is that certainly for claims that, well, it's a variety of claims. I think for some of these claims corresponding to years in which they're yeah, I think our information is that the amount of claims, and I think that this is indicated by this, that the number of claims have dropped since Prepa has gone into Title III protection. And I believe the last year for audited financial financial results have been audited for Prepa is 2017. But at least publicly, what's available is 2016. I've been told that 2017 is ready, although I haven't seen those results.
Okay.
So it's information that much of which has not been subject to audit.
Okay, understand. And thanks. Going back to your testimony, Mr. Hurtado, on lines 99 to 101, you stated that the terms of service will save Luma as operator and Prepa as asset owner and electric utility customers considerable resources, money and time spent dealing with claims for compensation and damages. Can you describe or can you define the term considerable resources, and can you describe the level in terms of dollars invested on an annual basis or any other basis that Luma might have regarding lawsuits and claims?
Yeah, I think roughly speaking, from the information that we have, it's millions to tens of millions of dollars in terms of monetary, as I stated before, the historical, and then the time and effort spent both by attorneys and other professionals running down the claims, defending them, and everything, and all of that. So that is material. It's not necessarily a huge number.
Okay, understand. It's just that when you say tens of millions, it seems like a very generic figure or just like a ballpark estimate. What are you basing that phrase, tens of millions, upon? And is it on a yearly basis? Is it on the entire 10-year period? What is it that we're...
I base it on the fact that, you know, it costs millions of dollars, so single millions of dollars to have the staff to do this. Fees to attorneys are easily in the millions of dollars. So it's very easy for me to think that the total cost in any single year would be about $10 million. That's all I'm saying. Exactly the amount, I don't have an estimate for that. And again, I think that this is one element or one of the benefits that we think would accrue to customers from the limitation of liability that we've proposed, but it's certainly not the only reason that we would have it. And on its own, I'm not sure that it would be a reason for a limitation of liability of the sort. It would be up to the commission to determine whether it was worth the time and effort and resources of the utility to be spending on this. But that's not our primary concern. Our primary concern is the forward-looking risk, again, of an unbounded loss or something which we cannot calculate at this time.
Okay. I understand, Mr. Hurtado, and thank you very much. And I understand that Luma not having the operations of the system, not being in charge of the operations of the system yet, is very difficult to obtain certain information. However, you and Mr. Terzic, all over your statement, all on your pre-filed testimony, states the risk of the dollars and the rate increase and the rate impact that these lawsuits or these claims have or may have over the utility. So now you're saying that we're talking about $10 million, just to put it a round number, and $988,000 out of $460 million over a period of 10 years on a $3,000 overall budget. So my question is, what is the rate impact that these lawsuits have had on Prepa, and what is the rate impact looking forward into the future?
So the rate impact of these claims from the information we've got is quite small. The rate impact looking forward could be quite large. As I think that the phrase is something like, historical financial results are not indicative of future performance. I mean, that's, if we based everything on what performance had been financially and only on historical and didn't have some forward-looking estimate of risk, then we wouldn't be thinking prudently about the future of the utility.
Okay, I understand. So what is your basis to state that in the future, the future will immensely or deviate considerably from the historical?
I think
other than the configuration and of the system under the contract.
Other than the configuration of the system under the contract, I think that the basis is looking at the history in the electric utility sector, taking into consideration the heightened risk from events because of climate change, the fact that damages from those events have steadily increased throughout the United States and North America and the Caribbean, and the fact that utilities have been subject to multi-billion-dollar claims or class action suits, that it is reasonable to think that this sort of a catastrophic loss could befall Prepa and affect Prepa and Luma's ability to effectively serve customers.
Okay.
So
and
it's based on, again, it is a risk. We think it's a reasonable risk, and it's based on looking at the overall context.
okay, thank you. So essentially the same answer. I'm going to ask the same follow-up question. Gross negligence and willful misconduct under that scenario are human factors, not the catastrophic aftermath of increased hurricane or earthquake activities in the island. Okay, moving on to the next. I'm going to reference the answers. The answer RFI Luma MI-2021-0007. I'm not going to read it. It's PREP 0001.
Yes, sir.
Okay, Luma's proposed initial budget, I'm sorry, let me rephrase that. On the second paragraph of the response, states that Luma's proposed initial budget allocate $57.7 million in FY22 for property and casualty insurance. First of all, what will this insurance cover?
I will, if it's okay, Commissioner, I'd like to have John Stone, our Director of Risk Management, answer that question since he's the one who understands these things.
Mr. Stone, okay, yes, and he's been previously Attorney Torres. Can you confirm that Mr. Stone was attested today?
Yes, this is Antonio Torre. He was sworn in. Thank you.
Thank you. Mr. Stone, good morning.
Good morning.
Do you need me to repeat the question, sir, or?
No, sir, I haven't. So what was anticipated in the initial budget in that $56+ million number were all the property and casualty coverages that we expect to need to pay for that Prepa currently covers. So it's broken down into two main groups, the property and boiler and machinery, which covers all the assets that we choose to insure in generation and in T&D across the island. And then the other policies are more specific policies around liability, like directors and officers or general liability and excess. So generally, it's two different sides of the insurance program.
Okay. So essentially, it will be the same kind of insurance that Prepa has.
Correct.
Does it have the same amount of deductible, $1 million for liability?
That would be correct. That is what is anticipated, although it's hard. It's a very hard insurance market right now, and we don't have prescient knowledge of what may happen next year. Deductibles may need to go up, but currently we understand that is capable. We are potentially capable of making those same deductibles.
Okay, and Prepa has a self-insured $1 million. Will that be the case as well when Luma enters into operation? When and if Luma enters the operation of the system?
Yes, sir.
Question mark.
Yes, sir.
Okay, thanks. So if for larger claims, you do have this type of insurance, why is it reasonable to have gross misconduct? Let me rephrase that. Gross negligence and willful misconduct liability waiver? Either Mr. Hurtado or Mr. Stone.
it provides, I'll just speak briefly, it provides a shield against a great number of claims and would allow us to control a bit more of our risk in the attempt of getting rid of some fraudulent claims and pushing some things off that we know we're going to get hit by, especially after we come out of Title III. I think we're going to be quite a large target, and it's that's my side of it. Thank you.
Okay, thank you, Mr. Stone. Mr. Hurtado, under the terms of the operation and maintenance agreement, will the cost of Luma's insurance be considered a pass-through expense, or will it be Luma responsible for this out of the service fee?
My understanding is that that would be a T&D pass-through expenditure under the terms of the contract, Mr. Commissioner.
Okay, thank you. All right. Mr. Hurtado, based on the insurance, liability insurance that Luma will carry among, together with Prepa, the question is, why the need for such encompassing liability waiver? If the answer is the same as before, just state so.
Yeah, I don't think that the. I'm sorry, I didn't understand that first part. Could you repeat your question, Commissioner?
Yes, sir. Based on the insurance, we've been talking about multi-billion-dollar lawsuits, and the people are going to sue after catastrophic events. Based on the insurance and the liability that Mr. Stone, or the liability coverage that Mr. Stone just described, which is very similar to the one that Prepa has right now. Why will such encompassing liability waiver be required?
In my opinion, because the sort of claim that we're talking about, the sort of catastrophic claim that would far exceed the risk mitigation that would be provided by commercial insurance.
Okay, thank you. On lines, on lines 107 and 108 of your testimony, Mr. Hurtado, you're talking that the current Prepa's terms of service are not consistent with prudent utility practice and will not allow Luma to meet contract standards and provide service in accordance with with prudent utility practice or practices. Can you explain how the current terms of service will not allow Luma to meet its contract standards? And first of all, what are the contract standards that we're talking about, and how Luma will not be able to meet them?
Sure. So the contract standards as defined under the OMA, my understanding, is a broad-ranging definition. So it includes all of the obligations under the O&M agreement that are specific that Luma must carry out. It also includes applicable law, regulation, prudent utility practice, and warranties from equipment manufacturers that are required or specified. In particular, I think in this case that the focus has been on prudent utility practice, and in managing outages and in managing emergency situations, or in managing situations in which there may be imperfect service or service that has to be curtailed in particular, or just in restoring that service after some sort of an event. The liability of the utility is not typically taken into account when those actions are taken by the utility in North America, because of the existence, I think, of limited liability, of the sort of limitations that we're asking for in the waiver. And so that's the connection that we're making there, as well as obviously the exposure to increasing rates in the future, or just a larger dedication of resources to paying claims than is the current case.
Okay. Yeah. I understand the risk of higher rates and the risk of allocating more resources, and I understand the impacts that right now Luma has expressed that are unknown and need protection from. But the question is, what specific actions with regards to the contract standards is Luma prevented from taking, or will Luma not take under the current terms of service? And why the terms of service are needed specifically for meeting those standards or those contract standards? That's what's not clear to me right now.
Well, thanks for your question, Commissioner. So I think that we are attempting and will achieve bringing Prepa from a current state, which is literally at the bottom of North American utilities, to something which is more the norm and up to industry standards, initially up to minimum industry standards. That includes activities in restoration of service, lots of other activities that we've covered in other dockets. It is typical in North American utilities for those activities to be carried out with a limitation of liability to the utilities. And so we consider that part and parcel of going along with prudent utility practices is the utility having the protections that are typical and customary for North American utilities.
So,
This is Attorney Mercado. It's almost 10:45. I don't know if Ms. Caron did not mention a break that we have had customarily. I don't know if this is a good juncture to have the break. Sorry for the interrupt.
Yeah, Mr. Torres, I believe it's a good junction to have a break at your discretion. Or I'm sorry, Ms. Caron is the one that is conducting the meeting today.
Yes, sure. Let's have a 10-minute break. It's 10:41. Let's reconvene at 10:42. Let's reconvene at 10:52.
Thank you.
Thank you.
Good morning. Attorney Mercado, I just want to verify that everyone is ready on your end.
Lost the connection. It's being rebooted now, so in a minute, I hopefully less than a minute, but we're rebooting one connection.
Thank you. Then let me know when you're ready, please. Attorney Bolaños, I just want to verify that everyone's ready on your end.
Hi, yes, we are.
Thank you.
Good morning, Margarita Mercado for Luma. We've resolved the technical issue, all connected and ready to proceed. Thank you.
Thank you. Then we will continue with the technical conference for today.
All right. All right, Mr. Hurtado, good morning again, and welcome back. All right. Let's go really quick to lines 110 and 111 of your testimony. You stated that the current terms of service expose Prepa to claims for catastrophic losses whose payment will only lead to financial distress. We've been talking about this, for the best part of the morning, but can you define financial distress?
I think in this context,
within this context, yes.
Yeah, in this context, it's a financial condition which would severely impact the ability to provide the service under the contract standards.
Okay, understand. I understand that Prepa is under Title III right now, but is Prepa under financial distress due to lawsuits and claim payments?
Prepa certainly has had many issues meeting its financial obligations. Partially because of that, my understanding is that current suits are frozen. And so there's a standstill on many of those actions. So, I think it's under Title III because it couldn't meet the obligations it had contracted to meet.
Understand. Thanks. Let's go now. I'm gonna change gears here, and can we go to line 157 of your line 157 to 160 of your testimony? It states that the proposed terms of service are not intended to limit the protections of the processes currently established under the Office of Independent Consumer Protection Office to protect customers and the Puerto Rico Energy Bureau's authority to exercise oversight over the electric sector in general and Prepa and Luma in particular. Sir, can you expand? I know that you've briefly touched about this topic, but can you expand upon this statement and what, from Luma's perspective, what does it mean?
Thank you, Commissioner, for the question. I think from our perspective, it means that in my view, the most appropriate party to judge both the damages, or let's say that the claims that could be applicable to Luma or Prepa, and then the redress that's necessary for that to address damages to customers is PREP, because PREP also has the ability to look at what the potential impact would be to not just to those particular customers, but to all customer classes. And part of the Energy Board's overall mandate is to make judgments based on public interest, reasonableness, and maintaining just and reasonable rates.
Okay, understand. And to that effect, there are several processes or several proceedings held before the Energy Bureau. Two major ones are the bill objections review and also the claims against Prepa and now Prepa and Luma or any other energy service company based on the type of service or any other matters that are normally not economic in nature. Essentially, it's not a monetary issue. First of all, I want to address the bill objections. Under Article 6.27 of Act 57 of 2014, there is a very specific proceeding or procedure that all electric customers must follow to object their bills. That essentially will end up at the Energy Bureau if the customer is not satisfied with Prepa's or Luma's determination. The question is, will the waiver, can you confirm that if approved, the liability waiver will not in any way, it will not apply to that process described on Section 6.27 and Regulation 8863 from the Energy Bureau?
To my knowledge and my understanding of the waiver that's being sought, it's specifically to civil court. It applies to civil courts and civil claims in the courts, and not to the processes that are specific to the PREP or the Office of Consumer Protection.
Okay, and so with regards to the bill objections, the answer will be, the short answer will be, to your knowledge.
I think
Sorry, Commissioner. I think we lost you for a second.
Oh, I'm sorry. I was asking, okay, so with regards to that specific process, bill objections, the short answer will be, it's a yes or no answer. To the best of your knowledge.
Right, but I haven't heard a complete question. I'm sorry, Commissioner,
Okay.
if I just...
That's fine. No, I'm not the most technological person in the world.
So, well,
with regards to the bill objection process described on Article 6.27 of Act 57, 2014, and Regulation 8863 of the Energy Bureau, this is just a bill objections cases. Short answer is a yes or no. Will the liability waiver, if approved, apply to those type of processes?
So, Commissioner, thank you for your question. But without looking at the specifics of that article and that regulation, my understanding is that the limitation of liability, which we've requested, would not have any impact on those processes. And in particular, I guess because if you're talking about bill objections, that wouldn't be covered just generally, whether or not whatever type of process it would be, because that's not the purpose of the liability waiver.
Okay, thank you. Now, moving on to the next type of process, article, and again, subject to verification. I'm sorry that I'm throwing a lot of articles and laws and regulation at you, Mr. Hurtado. I understand that you're not a lawyer. I'm just trying to have a complete record.
Yes, sir. Yeah.
Subject to verification. That's the phrase that lawyers like to use. Subject to verification. Article 6.4 of Act 57, 2014 establishes that the Energy Bureau has jurisdiction over cases and disputes regarding non-compliance with the energy public policy as established in Act 17, 2019, which is the energy policy, non-compliance with the mandates of Act 83 of May 2 of 1941, and Act 17 of 2019. Essentially, non-compliance with these laws, the Energy Bureau has primary jurisdiction over that. Can you confirm that the requested liability waiver does not apply to such instances? In other words, these will not bar customers from filing claims before the Energy Bureau for violation of these provisions.
That is my understanding of the waiver, that it will not change or modify the Energy Bureau's jurisdiction or its powers to regulate Prepa or Luma.
Okay, thank you. So, being that as it may, if the Energy Bureau approves the change in Prepa's terms of service, will Luma have any objections to include language similar to that on lines 157 and 160 of your testimony? Essentially, put it in the waiver, or whatever language the Energy Bureau approves, that it will not infringe, or it's not intended to create the circumstances that you describe on those lines. Will Luma have an objection of including such language?
Thank you for your question, Commissioner. I think we have to look at the specific language and the context of it, but conceptually, my view is that there would not be an issue with that. But again, it's subject to seeing the language in the full context.
I would add, Attorney Mercado, for the record, that obviously that isn't included in the text of the OMA, which is a contract by 3 parties. I acknowledge that Section 4.1G specifies that the terms of service would be approved, or request for approval by the Bureau would be filed. And legally, also an analysis would be made on whether it is proper, reasonable, or within usual utility practice to include caveats such as that proposed. So it would have to be also a legal analysis on whether a utility tariff with that caveat and in the terms of service liability waivers will be proper.
At least in the if I may, in the tariffs that I've reviewed, I haven't seen any sort of limitation like that, or rather extra specification about the tariff not limiting the Public Service Commission or the local bureau or commission that has jurisdiction over the utility about having any effect on it. It's not typical to have that sort of language in the tariffs on the ones that I've reviewed.
Understand. Okay, I'll take your answer at face value. Thanks. Moving to lines 167 to 170. Essentially, you're describing that the terms of service will allow Luma, as operator of Prepa's T&D system, to fulfill the requirement by law to provide essential public services indiscriminately to all customers, regardless of the potential risk to Prepa that the connection of these customers to electrical service may pose. What do you mean by the potential risk to Prepa that the connection of these customers to the electrical system may pose? What do you mean by that statement?
Thank you, Commissioner, for your question. I think that question refers to when you look at an entity like Prepa, and in this case, Luma acting as Prepa's operator, entities don't have a choice on whether or not to provide service to a customer. And let's say a company that was not as highly regulated would have the ability to basically refuse service. That is not something that Prepa or Luma can do as highly regulated entities. And so part of the reasoning behind a limitation of liability zone we presented is that as a highly regulated entity, you don't want the company to be doing any sort of analysis on what liability it could be exposed to because it's serving particular customers or particular types of customers or customers in particular types of situations. A private entity that is not as highly regulated, I think as a matter of course would make that sort of a judgment, can decide to just refuse service.
Okay, so essentially what you're, if I understand correctly, since Prepa cannot refuse service, the trade-off will be to waiver that liability, waiver some liability up to whatever extent. That's what we're discussing here. So the trade-off will be that to limit the liability of this utility to that customer that they cannot refuse. Is that a general statement?
Can you repeat the question, the
Yes, sir.
statement?
Yes, I'm sorry. Essentially, what you're saying is that the liability waiver, let me rephrase that. It's not that you're saying that. It is my understanding of the phrase that the liability waiver is a trade-off of accepting this customer that cannot be refused service.
Commissioner, I don't think it's a trade-off. I just think it's in the nature of the utility service that you don't want utilities to be doing some sort of a judgment of the liability to which they're exposed because they have to provide service to X, Y, or Z class of customer or type of customer or specific customers that maybe have specific conditions. I just think it's part of it's part of the I guess condition of those entities as entities that must provide essential public service and as an entity that has an obligation to be a provider of last resort.
This is Attorney Mercado for the record. I just want to direct the commissioners to the petition for approval of the terms of service, where the case law around pages 12 and 13 and onwards discusses this very consideration that Commissioner Rivera has.
You know, thank you very much, Attorney Mercado, and yeah, we're very familiar with that, and very familiar with the cases. Just I have a witness in front of me. Okay.
Completely record. Thank you for the record.
And I understand the legal determination. I just want the witness to clarify his statement. Thank you. Okay. Thank you, Mr. Hurtado, for that. I only have a couple questions for you, Mr. Hurtado. Well, I'm not going to say a couple questions. I have some more questions. Going to line 174 to 184 of your testimony. Essentially, this is describing that or stating that the terms of service would not alter the heavily regulated nature of Luma's operation or Prep's oversight. Essentially, it's kind of a reiteration of the language that we were discussing a couple of minutes ago. Lines 182 to 184, you state that Luma is also subject to the Prep's oversight with respect to the implementation of various provisions of the OMA, including the establishment of performance metrics, system operation principles, and system remediation plan. With regards to the performance metrics, the establishment of performance metrics, can you confirm that the liability waiver, if approved in whatever form, will not affect the Energy Bureau's power or ability to establish those metrics and any other performance-based mechanism that it deems appropriate? Question mark.
The purpose of the liability waiver is to limit third-party claims in the civil courts, and that's the focus and its intent.
So the short answer to the question will be, I'm sorry, I know that's an answer. That's an answer, but doesn't answer affirmatively the question that was posed.
I think it's an answer to your question, Commissioner.
Okay.
In my information, respectfully.
Okay, understand. So the same question with regards to language on the waiver. Will Luma have any objections of adding language to the final approved waiver to the effect that the waiver or the liability waiver will not infringe in the Energy Bureau's ability or powers to establish performance metrics and performance incentive mechanisms? Question mark.
Yeah, I think our current request to the Bureau is to approve the liability waiver language that we presented. And we would have to look at if the Bureau so decides or is looking at different language, we would have to look at that specific language in its context and react to that. after a proper analysis. So what we're asking for is the language that we've submitted.
Okay, excellent. Thank you very much. And understand the question, the answer. Thanks. This was mentioned before, either by you or Mr. Terzic. Could you confirm that it is Luma's understanding that the terms of service or the proposed terms of service, if approved by the Bureau, by the Energy Bureau, are prospective in nature?
This is Bronco Terzic. Was that for me, Commissioner?
No, that was from Mr. Hurtado. What's Luma's understanding?
Commissioner, by prospective in nature, you mean that it would be in effect at the time that it is approved and put into effect, and from that point moving forward?
Right.
That's my understanding.
Yes, so essentially will not be applied retroactively to any pending cases.
I think it would only apply to the time from when it's put in place moving forward.
Okay, excellent, thanks. As it was presented on that attachment 3, there are several cases that are still pending before Prepa or before the courts. How will Luma/Prepa deal with the claims that have been filed that are still pending up to now?
Sorry, Commissioner, are you asking what?
Yes, I am asking. There is a...
What measures will take, in relation to these claims, or how our legal department will function, or?
Okay, maybe I'm not being very clear. I apologize about that.
No.
Let's say that the liability waiver is approved in any shape or form, and it is, like you said, is prospective in nature. Like Mr. Terzic said, rate making is prospective. You cannot go back in time and apply future rate or future these provisions like this to past actions. Well, there is a caveat to that, which is the provisional rate that you can retroactive apply it in a rate case scenario, but that is not the case here. So the question is, there is still a lot of lawsuits and claims pending. How will Luma and Prepa manage these cases that are still pending? How is it going to be? How are they going to be managed from this point forward?
My understanding is that, in general, the existing claims and lawsuits will be managed by Prepa, and new claims will primarily be managed by Luma. In general, I think that Prepa and Luma will exercise their legal rights and defend Prepa and Luma in those cases as appropriate, and seek to minimize the losses or the claims or the payments that are made. But it all depends on each specific case. I know that, yeah. I think it just depends on the specific case. I don't know that generally they're going to carry out their duties to process those claims or to work through those lawsuits based on the facts of each of the cases.
Okay, thanks. Thank you, Mr. Hurtado. Those are the questions that I have for you for now. Mr. Terzic, I do have several questions, sir. I didn't forget about you. I do have several additional questions, if you bear with me. On lines 221, 222 of your testimony. But this is one of the instances. But in several instances, you mentioned on several occasions the term claims payment system as it pertains to Prepa. And can you describe such system and what do you mean by that term?
That would be the general term for the people at Prepa who are handling the current claims. That would be the attorneys, the investigators, the engineers, who are employees. It would also be any outside counsel that Prepa uses. My understanding is they have a large staff dedicated and working on these 400 cases that we're talking about.
Okay, thanks. So essentially, it's essentially how Prepa manages their cases, their load, and the claims and lawsuits that arises from the current terms of service.
Yes, they must have a system. They have people employed, processes, etc.
Okay, all right, thanks. Going to lines 229 to 231 of your testimony, you mentioned, and I'm quoting, one of the few tools available to regulators to reduce costs to a utility which is mostly subject to market prices for labor, material, and services is that of adopting a more restricted limitations of liability in a terms of service. I know that we discussed a little bit about this statement, but I think is central to your testimony. Can you expand a little bit on this? Can you expand a little bit on this? I'll ask follow-up questions.
Sure. Having been the CEO of a utility and also having been a state commissioner, I'm very familiar with the two different roles and who controls what and where the costs occur. The commission cannot change any costs that are incurred other than they can change the depreciation rate, which is exclusively to the commission, and that goes into the revenue requirement as a number, but they can't, even if they change their return on equity, that is an estimate, it's not a cost. And so that doesn't change. The only other kind of thing I could think of where the regulator actually could control the cost or influence the cost are things like adopting a terms of service which would reduce the amount of money spent, might reduce the insurance claim. So it is an area, one of the few areas, maybe not the only area, but one of the few areas where the regulator directly impacts the costs on the utility. Of course, the commission can also order certain projects, certain programs, which are line item specific, but this is one of those sort of generic ones that commission can affect.
Okay. Understand. And based on our conversation today, where to put that line up to here you cannot claim, and from this point forward will depend circumstances and other factors that we've been discussing this morning. I'm not going to go over again because basically we'll be going back, but understand now better what you're trying to tell us. On lines 242 to 245, essentially it's a quote. It's a quote from Mr. Timothy Brennan. I'm not going to go in there. Essentially, what we're talking about is that having a payment system like the one Prepa has induces, essentially removes the initiative or the incentive for the customer to mitigate their own losses. That's essentially or the heart of the quote. Can you confirm that?
Yes, exactly right, and it's a very good observation, Commissioner. Timothy Brennan is writing for the Resources for the Future, which by all estimates is a pro-consumer organization, historically pro-consumer, et cetera. And so he was looking at this, I believe, right after the big derecho. You'll notice this is a 2013 report. The big derecho in the Northeast was 2012. And so a number of academics, including colleagues of mine, looked at, once again, the limitation of liability, the payment system, to see if things could be improved. And this was one of the surprising, I think, results to me was that Timothy Brennan came up with this conclusion that having the strict liability may not be the best policy decision.
Understand. And now the flip side of that, utility that is completely removed from liability won't have the same effect on that utility, essentially remove the incentive to perform.
Attorney Mercado, Commissioner, I would like to request for clarification on what you mean by completely removed from liability. We have been discussing different
Excellent,
areas.
thank you.
If you could, Commissioner.
I'm trying. I understand. I'm trying to. Yeah, I didn't freeze. I'm trying to rephrase the question.
Okay.
That is the way that's more useful. Let me rephrase that. Will, on the flip side of that, will an utility that is shielded or heavily shielded from liability, won't that have the same effect of removing the incentive to perform? How is that, Attorney Mercado?
Yeah, I would have the same statement. Completely shielded or significantly shielded, it's not necessarily has basis in a tariff or in liability waiver per se or in law. So I would like more specificity on what you mean within the scope of
Within the scope of a liability waiver. And again, this is an expert and very knowledgeable expert based on his resume, and I'm just taking advantage of him that he's here with us as a regulator. So.
No, I thank you for that. I just want to have the record clear. But yeah, you can restate your question, and I'm sure he can.
Thank you for the permission to restating my question.
It's not a permission. It's just because I interrupted.
Okay. Thank you. So, Mr. Terzic, in the context of a liability waiver, a heavily shielded or a shielded company, let's take the adverb out, or the shielded, and again, it's your opinion, and I'm not talking specifics with Prepa, or this specific case, but in terms of what we're talking about, that a fully compensatory or a compensatory system will remove the incentives of the customers to actually mitigate their own damages. Will a shielded company, through a liability waiver, let's put it that way, wouldn't have the same effect of removing the incentive to perform?
Yes, I addressed that. Thank you. It's a perfect question, Commissioner. I addressed that on lines 372 to 375, and in the answer there where I talk about the arguments in favor of compensation, once again, there is the suspicion that a utility for financial incentive purposes could curtail maintenance, could cut costs in order to improve the bottom line. That's generally a charge made against investor-owned utilities. It is not a charge made against municipal and government systems who don't have profit maximization as their goal. And even in those cases, performance indicators, complaints on the system, other tools that the regulator has will be in effect. So if there is a degradation of service quality for whatever reason, the regulator will become aware of it. They will have outage statistics. They will have consumer complaint statistics. They will have government complaint statistics, because when things go wrong, people call the governor and they call a senator and they call other political figures, and the commission then gets the brunt of all of that. Believe me, I know I've handled those calls myself. So that the other notion, of course, is if service stops, there's no revenue. If I fail to deliver service to a customer, the kilowatt hours don't get sold, and the revenue drops, and so there's no incentive for a normal businessman. And I was the CEO of a utility. I had no incentive to not provide service to my customer to not make sales. The incentive doesn't work that way. You want to make the sales, you want to deliver the service, you want to deliver more service, you want to deliver better service. So that's what maximizes profits. The notion that you're gonna run a utility by somehow squeezing costs doesn't in the long run, and damaging your asset investments is absolutely wrong and misguided. The utilities are very, for example, asset intensive. The typical utility has $3 to $4 of investment for every dollar of revenue. That's extremely unusual. So your assets as a investor-owned utility, your assets are what you make profit on. Why would you let your assets deteriorate? Makes no sense whatsoever. So I'm sorry, I'm a little long-winded. It's a favorite subject of mine, and I'll apologize. But the other tools that the regulator have, the reporting mechanisms that I point to here, performance-based rate making, the indicators that you'll have with Luma, Prepa, all of those will give you the information you need to make the decisions that you need about service quality.
Okay. Thank you very much for. Yeah, go ahead.
Mr. Rivera, can I ask a question?
Yeah, no, go ahead.
Okay, thank you. Reality is that the liability waiver for ordinary negligence is the standard in the industry. That's right?
There are some that include ordinary negligence, others that do not. It varies.
But can we agree that ordinary negligence liability waiver is the standard in the industry, typically?
There are many cases of it, yes, sir.
But this is not the case for gross negligence and willful misconduct.
It's less frequent, yes, sir.
Thank you.
Okay. Thank you, Mr. Chairman. Mr. Tursik, again, in general terms, like I said, as a regulator, I'm taking advantage of a very good resource, an expert witness. Can you expand a little bit on incentives and penalties for performance, and how can they induce performance on a utility in general?
Yes, for the investor-owned utility, there are two classes of incentives. One is the overall performance-based rate making, which is a system of rate making where the prices are fixed for a particular period, and during that period, if the management can lower costs through greater efficiency, the regulator will not step in and take the higher profits. That is performance-based rate making. There are also specific performance incentive programs that regulators have, which say if you do a specific program, like if you weatherize, I had this in Wisconsin, if you weatherize 10,000 homes in a year, will allow you to have this profit. If you weatherize 50,000, will allow you a little more earned profit. So there are these individual incentive programs to incent specific actions, and then there's the overall performance-based rate making system, which I understand in your statutes you are allowed by law to implement if you'd like. So those are the two kinds of incentive systems. On the penalties are generally retroactive, and they generally have come during a period where a utility is in for a rate case, and the commission has looked at performance indicators, public testimony very frequently, and has said we would going forward we would give you a normal return on equity, but because of your failure to perform during the prior period, we are going to deduct a certain number of basis points as a penalty. And so you will be allowed to earn, or we're going to put less in the revenue requirement in the future because of poor performance in the past. Some states have done that.
Okay. I understand, and and that's again is basic theory on performance and penalties in rate making. Specific to Luma, a portion of Luma's compensation, besides the service fee that they will, the fixed service fee, it's essentially an additional portion based on performance. Throughout the day, we have heard that liability waivers essentially remove the utility or provides certain protection to the utility, and we extract performance. Other regulatory actions such as performance incentives. In this context, will those be appropriate tools for the Energy Bureau to use to extract such performance?
Yes, it's a bit of an unusual situation. The fact situation here is a bit different because we have the asset owner, the owner of the utility being Prepa. We have the management being Luma, so it's slightly different. The agreement between the operating and maintenance agreement has within it performance measures and statistics, which would be approved in the package that you have, and I think those are adequate for the purposes that we're looking at, incenting better performance out of the overall utility. There are indicators in there and various factors that you will look at. It's a slightly different two-step system rather than a single utility with a native management, if you will.
Okay, thank you. That's very helpful. Very helpful. Okay. Okay. You describe in the later parts of your testimony. You describe some arguments against the compensation system that we've been talking about on line 350. Hold on, lines 359 to 360 of your testimony. You stated that it is unfair for utilities to compensate customers when an outage is unpreventable, as it puts the utility in the role of an insurer. I have to think, first of all, can you expand a little bit about that argument? And I have a follow-on question on that.
Well, I don't know how I can say what's there differently. The utility provides service when it can. When it cannot, under a compensation system, it must pay, which would be the equivalent of the customer had insurance for loss of service, and in this case, the insurer is the utility. So your choice is you get insurance if when you use your insurance if you don't get service, or under this system, you don't get service from the utility and they compensate you for it. So they act like an insurer.
Okay, I understand. And I'm going to go ahead and say that I might agree with you in the sense that when an outage is unpreventable, it's very difficult because now you have like you said, the utility put himself in the shoes of an insurer. But I got a quick question. What happens when that outage is a result of gross negligence and willful misconduct? And then you have a customer that suffer some damage based on that because willful misconduct and gross negligence.
Well, what I believe what happens there is the regulator can step in and penalize the utility for that gross misconduct. It doesn't go unpenalized. It's just that from the customer standpoint, the cause of the outage is irrelevant. It doesn't matter whether the cause of the outage was act of God, an accident by a truck knocking down a pole, or purported gross negligence somewhere the customer is without service and would be treated the same under all conditions. However, the utility is not going to be treated the same by the regulator. You are going to treat a utility very differently which had a storm versus one where there is gross negligence on the part of management or attributable to the utility. That gross negligence will be treated through some other mechanism that you have, an investigation, a hearing, penalties, whatever tools are available. So the gross negligent would not go unpenalized if proven. It's just that from the customer standpoint, it doesn't matter why the service stopped. The customer will not be compensated for the stop in service, once again, because it's going to take a long time to investigate and prove whether there was or wasn't gross negligent in any event.
Okay, understand. Thank you for that. That's very helpful. When the chairman, with the question from the chairman regarding, I don't want to say the commonality, but how often are utilities given or approve a waiver for gross negligence and willful misconduct? What are the circumstances or why are the reasons that these other states or other jurisdictions exclude gross negligence and willful misconduct from their liability waivers? What are circumstances? I understand it's a wide range of circumstances, but I want to understand, since we don't have the circumstances in which they're included, I would like to explore the circumstances for which they are excluded.
In my research on this, I've looked at it quite a bit, and it very much has to do with state laws and what the state courts have upheld with respect to tariff provisions. The cases that were cited because there was an appeal to a court about this limitation of liability language. And some state courts have upheld the ability of state regulators to write very, very tight, very strict. Other state courts, in my reading, have indicated that the regulators have gone too far. And so it is very, very state specific vis-a-vis what's in the Constitution. Whether, for example, the limited liability in Wisconsin is in the law. It's in the state statute. It's not in the order of the commission. As you know, the orders of the commissions are filed rates and are legal orders that the courts will upheld. That's a filed rate is different than a state law, and in some, my understanding, in some jurisdictions, the courts have either upheld or they've overturned the discretion of the commission in writing these limitations on liability. So it's very very state specific. The general principle, from what I've been able to tell, is that the limitations are binding on state courts unless the courts find otherwise.
Okay. Besides Wisconsin, can you give us another example where gross negligence and willful misconduct are not included, and the reasons why, or the specifics?
They're not, or they are included?
They are not. Essentially, we discussed which one they are. Very few. I'm trying to explore the circumstances on where they're excluded.
Well, there are many places where it's there are different language where it's ordinary negligence or something. Without going into the history of any particular states, I really am not able to answer that answer that question. There are states that specifically exclude gross negligence and willful misconduct. I'm looking at North Dakota, for example. Others are silent on it and merely talk about normal negligence. So that is, they're totally silent on that aspect. And I guess there you'd have to go to the court to find out whether or not it would be applicable. Once again, I'm not a lawyer, so I'm not going to I can't opine on that, but other states, for example, I'm looking Nebraska, which is a public power, so it's a state-owned enterprise, excludes damage caused by negligence. Period.
Including ordinary negligence. Okay.
So yeah.
Okay, understand.
Yeah. It was hard to find these. They're buried in tariffs. People forget a normal residential tariff is 20 to 30 pages in the United States, and sometimes they're not even labeled this way, and they say other times they're not in the tariff, they're in a statute, so sometimes it's even hard to find them.
Yeah, believe me, we have been looking, and I agree with you. It's and I'm gonna stop there. I'm not gonna editorialize that. Okay. All right. Mr. Terzic and Mr. Hurtado, thank you very much. Those are the questions that I have for you. Again, thank you. You've been very helpful. I think the discussion has been extremely productive. And from my part, pending further other questions, I don't have anything else. Thank you very much.
Thank you, Commissioner.
Thank you, Commissioner Rivera. Are there any other questions from commissioners? Commissioner Ugarte.
Yes, hi. Mr. Hurtado, is there any other liability waiver option considered?
Excuse me, Commissioner, was there any other liability waiver option considered?
Yes.
No, that the language in the O&M was what we thought was appropriate and what was included in the OMA.
Okay, and in your opinion, with the system remediation in place, what is the probability that Luma being found liable for gross negligence?
It's Attorney Margarita Mercado. I appreciate the question. I think it calls for a bit of a speculation and opinion from a fact witness. He can, yeah. So that would be my take.
I wouldn't be comfortable. I wouldn't be comfortable speculating on that. As I mentioned several times to Commissioner Rivera's questions, I think that the situation we're in is one in which there's we have to consider the possibility and the risk implied from that, and it may or may not be based on historical performance.
Okay. And when we talk about the insurance cover and we talk about property and machinery, Johnstone said that it provides a shield to Prepa and Luma from liability. Then in your testimony, when it was one of the questions was, does approval of these terms of service shield Luma and Prepa from responsibility in connection with the TNT system? You said no. Please, for the record, explains the difference from Johnstone's statement and yours.
Sure. Well, I can explain my statement, Commissioner. When I'm saying that it does not shield us from responsibility, I'm referring specifically that the Energy Bureau retains the jurisdiction to regulate Luma and Prepa, and can make determinations and order Luma and Prepa to take actions to redress claims, can order payment of claims. It has a wide variety of actions it can take if it deems necessary, either to to redress specific claims for customers or to institute policy measures which it deems appropriate to address previous actions of the utility. So that's what I was referring to.
Thank you. I have no more questions.
Thank you, Commissioner Ugarte. Any additional questions from commissioners at this point?
Engineer Acaron, this is Commissioner Ramos. I have a follow-up question on it was stated that the amount of insurance in the initial budgets was around $65 million. I'm not sure if it was stated, but what is the split between the property insurance and asset insurance versus the liability insurance?
Commissioner Ramos, I'll let Mr. Stone answer it. Yeah, I just want to make sure we specify the difference between the cost of an insurance on an annual basis and the coverage amounts or other terms.
So the cost of the premiums for the insurance placement for the property program are over 90% of the annual amounts paid for all insurances. A very large piece of the overall spend on insurance, the property side with boiler and machinery.
Okay, so 90% of the 65 million. Okay.
Hi, Ms. Rock. Kaylin, I just want to clarify the amount. It's 56.7 million, not 65.
56.7?
Yes. So 90%, what John is referring to, is of 56.7 million.
Is that right? Yes, that's right.
Okay. Thank you. That's all I got.
Thank you. I would like to ask.
This is Commissioner.
Yes.
This is Commissioner Mateo. Good morning to everybody. I have one question, and for the Luma representatives and their consultants, you decide who can answer it. Of all of those jurisdictions in which it is typically common to have a liability waiver in the terms of service, how many of those jurisdictions have a legislated right for a cause of action when somebody causes damage to another person? Not on common law, legislated one.
Could you provide, I'm sorry, Commissioner, this is Mario Hurtado. I'm sorry, I don't quite understand the question. What if you could?
In Puerto Rico, we have
right versus common law.
Let me clarify for you before you answer. In Puerto Rico, we have certain laws that are put together in what we call a civil code. This is one of the differences between the legal system in Puerto Rico and the U.S. This is something we inherited from the Spaniard traditions. And in the civil code, there is some language that establishes a cause of action for somebody that has been caused damages by another person, either a natural person or a legal entity. So I was asking, in those jurisdictions where during your research you found that a liability waiver is typical, how many of those have also this kind of legally allowed cause of action for damages?
Thank you for your question, Commissioner. Could we have a minute on that to give you a proper answer?
Absolutely.
Thank you. Commissioner or Directora Acaron, could we pause for 5 minutes or 2 minutes?
Yes, let's take a 5-minute break.
Thank you very much.
Let us know when you're ready.
Yes, ma'am. Thank you. Directora Acaron, I'm sorry.
Sorry.
I think their return is.
Sorry for the delay. Margarita Mercado for the record. I think, are you able to hear me? Yes.
Yes.
Okay, so Mr. Terzic will issue a first answer, and then I will request leave from the Bureau to interject in this matter, since it's a legally based question or interpretation of law.
Thank you. This is Bronco Terzic. Commissioner, the survey I did, the research I did, looked at the terms of service as filed within the filed rates of the individual utilities. And so you would go to the individual utility, you would pull their terms of service, read the language here, and compare it to what has been proposed. That data source does not tell you anything about the law in the state, or whether, to answer the question that you had, it provides no information as to other litigation or standards or whatever. It merely is the filed rate of the utility with the terms of service as approved by the Public Service Commission or the Public Utility Commission. It does not contain the answer to your, unfortunately, the answer to your question.
This is Margarita Mercado, Counsel for Luma. Thank you, Commissioner Mateo, for the question. And I think you've raised an important issue of law with regards to the scope and nature of the terms of service and their interplay under Puerto Rico law, as you correctly mentioned, it's a civil code tradition and does not, although common law elements have been adopted in tort law for our civil liability provisions, the source of our code is civil in nature. And a bit of context of how the liability waiver was, the language is chosen precisely to include gross negligence and willful misconduct, as we have been discussing this morning. So because as commissioners may know, in Puerto Rico, there is no developed case law with degrees of negligence between simple or ordinary negligence, gross misconduct, or willful misconduct, and gross negligence. So it's a unitary system of negligence. That is why it was important to avoid artful pleading and litigation precisely of what negligence means under Puerto Rico law, that the terms gross negligence and willful misconducts were included as degrees within the unitary concept of negligence under Puerto Rico law. And it is a matter of interpretation, as has been discussed this morning, what would amount to gross negligence versus simple negligence, and also willful misconduct. A proposed interpretation of that is that we're talking about degrees of negligence. We're not talking about intentional criminal conduct. It's within negligence, the first step in negligence would be ordinary negligence, which is courts would look at what an ordinary person should have done in a particular circumstances and whether that person deviated from that standard of conduct. That's the ordinary negligence. Then we move to gross negligence, which involves a higher degree of negligence based on foreseeability of the damage that was caused, to what degree the situation was more severe to warrant imputation of a higher degree of foreseeability, and then you differentiate that from a simple negligence and say this person or this activity deviated more from the prudent person standard, and then it's gross negligence. And then the last degree of negligence will be the willful misconduct, which is a higher degree of consciousness of an act, or of more consciousness of what could have been the result of the action or inaction, and that's why it's willful misconduct, but it wouldn't be intentional or or directly intended to cause the action, which would be an intentional tort that wouldn't be covered. So the liability waivers as a legal matter, I would propose that it's important to have the three categories in the language of the liability waiver terms of service to avoid just having complaints tackle in the word grossly negligent or willful misconduct and avoid what the liability waiver, if approved, is meant to achieve, which is to provide protection from liability. Then the utility would have to incur in the costs of litigation just because a complaint stated gross negligence, and it's a matter of degree to be adjudicated in a factual basis. So it is important under Puerto Rico law to have the three categories or degrees of negligence, and then on a case-by-case basis, it will be adjudicated with the threshold from negligence to intent or intentional conduct will be crossed, which would not be covered by the terms of service. With regard to other tariffs, the standard or the tradition in the United States jurisdictions that have been cited is common law, not civil law. But as Mr. Terzic explained, the tariffs themselves do not provide the information on the history and background of the jurisdictions. But we could say that the common source of law in those jurisdictions, the most common one, as we have been discussing this morning, would be common law, not civil law.
Thank you very much. I have another question, and it's whether the liability waiver will extend to people who are not customers, but are somehow, under some scenarios, some damage was caused to them. And what I mean by this is, I do not have a Prepa account. I'm not a customer, and I receive a damage either because I touched some pole or something that was electrified or something. Would that liability waiver that is being requested extend to me?
Thank you for your question. Oh, sorry.
Yeah.
Thank you for your question, Commissioner. Just a second, check on something. Yeah, the liability waiver language we proposed would include well, could I have a minute on this answer? I want to make sure I'm addressing your question correctly. And I'm reading and not certain exactly what I'm reading.
Okay, thanks. Go ahead.
Commissioner, I was able to clarify. So the language says that Prepa directors, officers, et cetera, and contractors, which would be Luma, will not be liable to customers or any person, natural or legal, receiving power or electricity for any losses. So I think that this language is meant to address that the limitation of liability could apply to persons that are not customers, but it would only apply to those persons if they're receiving power or electricity. So it's related to the delivery of to electric service.
So it's gonna apply to anybody.
That is receiving power or electricity.
But in my example, to that person that is standing on a sidewalk and accidentally touches a pole that is energized and it's not supposed to be energized, that person is not receiving power. Is that going to apply to that person as well?
Personal injury.
So Commissioner Mateo, it's Attorney Mercado. I understand the importance of evaluating the scope of the liability waiver. It is a matter of, it will be a matter of case by case evaluation, the facts of the hypothetical, but the text of the liability waiver, it's tied to receipt of services, and then it will be a matter of adjudication whether the damage was in connection with that service.
Yeah, but I disagree with your statement, Attorney Mercado, because although courts are the ultimate interpreter of contract provisions, if you will,
yes,
what I'm asking is that the intent of the waiver to apply to this scenario that I'm talking about, which is, by the way, not that hypothetical.
Mm-hmm.
It has happened, and it's common occurrence for that to happen. It's so I'm not talking about something that is highly unlikely.
Commissioner, thanks for good.
Mm-hmm.
I'm sorry, I didn't mean to interrupt you.
Go ahead, please.
If you give me one minute, I'll answer your follow-up question.
Okay, thank you. Go ahead.
that time. Okay.
We have it now. Can you hear me, Commissioner?
Yes.
Thank you, Commissioner. Mario Hurtado for Luma. So my understanding of the waiver is that it is not intended to cover a situation of personal injury like the one that you mentioned. That's my understanding of the waiver.
Okay, so that's I hear you. So what is and for the benefit of the people that are watching this, what would be the benefit, the scope of the waiver? It's gonna cover monetary damages. For example, if I am a pharma manufacturer, if something happens with my service and I sue Luma and or Prepa, then the liability waiver will be the end of that lawsuit, right?
In that hypothetical, as you stated, my understanding would be if you're talking about a customer that's receiving service, there's an interruption of service for whatever reason. Because of that interruption of service, that person then makes a claim in a civil court and has claims, whatever they might be. The liability waiver, as I understand it, would limit the ability of that party to seek redress in the civil courts. It would not limit their ability to seek redress in front of the Prep or the Energy Bureau.
Okay, thank you very much. I don't have any other questions.
Thank you, Commissioner Mateo. I would like to ask our consultant, Mr. Guy Massa, if he has any follow-up questions at this point.
Yes. Excuse me. I would. Thank you very much. Just a few clarifying questions, if I may. This is Guy Mazza, consultant to the Prep. I'd like to first clarify a couple of questions that Chairman Edison of Villas Deliz asked and their responses. The first was, I believe the chair asked, how is the public interest best served by including gross negligence and willful misconduct in the liability waiver? And I believe Mr. Terzic replied, we are here only considering financial factors. Is that correct?
Yes, economic loss.
Economic loss. And that being the case, are there any other factors that should be addressed in determining what is in the public interest? Or is that the only one you think should be addressed in determining the public interest?
Obviously, there are issues of discrimination, issues of fairness. I mean, not as you well know,